May I please lot. Item number 5 lot. Immediate legal accommodation lot. Regarding that file of tender, file of ship, we could not locate it total. So after that, we have only 18 staff lotship. All 200 staff has been terminated in legal action. It will staff lot.
So how many? So who's for the other side?
Yes, he has waited for 6 years lotship, just for 10 days lotship, requesting him to wait.
Okay, then when do we list?
On April 2nd, lotship, no military.
We have picked the number of it.
He has waited 6 days lotship because of non-filing of your identity. Yeah, no filing. Yeah, I will, we are not equal. They are celebrating and they are for the, but some reasons I am.
Yes. 28, you bring 28.
All are holiday lotship. From 22nd, it is a holiday. Oh, it's okay, gone through, but no further.
Okay, right, Mr. P. Sharma. The council for the fishery department.
No, AFDC lot.
Gave this space for time to produce the report as the same could not be traced. So some this is the matter on 2-4.
Highly obliged.
And I'm praying for listening of this matter from tomorrow. We are running the shelter homes finder.
Running?
We are shelter home for women and children under the social welfare department. Suddenly, my government is going to notification and asking us to hand over all the infrastructure and stuff to them tomorrow. Deeply obliged.
Day after tomorrow? Day after tomorrow.
Deeply obliged.
Lordship, item number 19.
Yes.
The matter be listed on some other day.
And where's the petitioner's counsel?
We have
Any objection
It
on the paper adjournment made on behalf of the counsel for the water resource department, Ms. K. Loda, which is not objected to by Mr. S. Sharma. This is the matter. Please.
obliged, your lordship.
may pleasure lordship for listing the
Huh?
listing on
New matter, old matter, what?
the 8 million matter lordship the on 17 or 18 lordship.
17 or 18 April.
No, 27 or 28.
No. Next week, no chance. When? What are you talking about?
On 4th April. Lordship.
You said 17 or 18 April. Now you want 4th April. What is it?
On first week of April. Lordship. 4th.
Why? What is the matter about?
The settlement of the heart load.
When is it going to end?
So I'm the highest bidder.
When is it going to end?
So the issue notice lordship.
Yes,
In the
madam, what do you want?
July lordship.
You give after April, after the bill.
Lordship, item number 6.
Item 6,
and-
yes.
Really sorry, lordship, for making this mention because the matter is fixed, but there are some personal difficulties of the council. We have informed the.
Let me see this last item 6.
I put a petition lordship.
Huh?
I'm going to petition item number 6 to be an objection because it's not informed.
Lordship, it has informed you.
Apart from that lordship, we have taken 5 or 6 settlements for the pretext of fighting entity. Now going to give it to fight. There's nothing but delaying text.
Yes, I know. We have. This matter has been heard at length.
Yes, lordship, on last day it was hard.
Where it is.
Huh?
There was a day that was very written.
Written note?
Yes, Lord.
What written note?
For our petition. The petition. There is
Lordship,
nothing but
there are some personal difficulties.
What personal difficulty? Where is he? Which court?
No, not in court. There's some personal difficulties. So he was informed me in the morning and it was informed to them.
Previous orders, they have been taking time in the pretext of filing affidavit, which they are not filing.
We'll list it there for tomorrow.
Lordship, in the first week of
Why? He's not going to be here there for tomorroh. He will be here. He doesn't want
Yes,
to come to this court.
I will inform.
Right. On the prayer for adjournment made on behalf of Mr. R.J. Das.
Yes.
Then it's counsel for the respondent. Number one, this is the matter. After tomorrow.
Thank you.
No further adjournment will be given on the fifth.
May I please your lordship? Lordship, prayer for listing of a WPC, which is in 2018 meter,
Item?
not item, means listing, mentioning for listing.
Yeah.
WPC 2018 meter, on last two occasions it has been left out, and we have approached the registry also. Kindly release the matter on 22nd. There is a urgency. Respondent number 3 is getting superannuation in end of March, retiring on March.
So, what is the matter about?
It is in labor court decision challenged by the petitioner.
Mr. Counsel, not this. He's retiring.
Is
And
retiring
so,
on.
how does that, so it's good, he's retiring, so what does it matter?
There are some complications.
What complications?
I will not.
You tell me the case. To understand your problem, I have got to understand the case.
So the judgment was in favor of ours, but the petitioner has challenged the labor court decisions, and now we have there are some difficulties if we retire and the judgment are given later on. I will not be able to.
You are going to retire.
Yes, respondent 3.
Or you are the respondent number 3. Difficult. This is the matter on 28.
May I please your lordship? Lordship, I pray for listing of two interlocutory
Huh?
applications. My lord, I pray for listing of two interlocutory applications. My lord, for implement of Ministry of Health Secretary as a party respondent. Keep your best. May I please your lordship? Your lordship, I pray for listing of a matter for admission, your lordship. Any day, your lordship, next week or day after next week, your lordship.
You give a date. In April.
Much obliged, your lordship.
I'd like to make a mention for withdrawal of a particular item. But if another matter, I have filed in a writ petition yesterday. The petitioners are landless agricultural laborers who have been residing at that particular land for 30 years. Lordship, now there is some people who are trying to evict them. But I filed it yesterday and it will listed for
I don't think that is which 5 ma'am.
like
In item number 14, my lord, we have received an affidavit yesterday, my lord, opposition. So I need 10 days time, my lord. to file.
Okay, Mr. Jay Barbuya, learned counsel for the petitioner, is granted 10 days time to file affidavit in reply. Yes, sir? This is the matter of attendance.
Okay.
Your lordship, a section mentioned for listing
Huh?
of matter regarding non-payment of contractor's bill. Order was given to implement Jal Shakti as a necessary party. I was
Filed, I was filed. When?
22nd of April.
Oh, April?
No,
Okay.
sorry, lordship, part.
Okay. No, April is fine.
Sorry,
Okay, okay.
August.
I pray for a listing of the petition matters. Certificate completed matter may be taken any convenient date, 27 or 28.
No, not this month.
Any other date,
What is
long pending.
the matter about?
Matter is regarding cooperative society matters, post of secretary.
Post of secretary? Is that a case? Is it relatable to this? I don't think it's relatable to this. That's, I think, a bench 3 or a bench 5 matter. I don't think it's a bench 4 matter.
Service matter earlier, my lord.
This is not a service bench, Mr. Counsel. This bench is for settlement and all those.
4.
This is bench 4,
Bench 3 matter.
probably.
some legal issues involved once the matter was taken up by one of the banks. I don't know, it's reflected, I'm ready to do this case. Like,
I don't know,
That's a-
I leave it up to your,
no, I can't do, it's a very small issue which, I used to hardly matter. My lord, for it hardly matter, but it's a very important issue which is involved.
no, you all make up your mind whether you want to do it before this bench or you.
Okay, fine. We have
Huh?
no objection. We have no objection. Otherwise, in some occasion, it was reflected as a part art in the public. Who does it, Mola?
Past. Position. It's from that.
Acha, Justice Arun Dev Chaudhary, says so at length. This is the matter for further hearing.
Lordship, item 1 and 2, it is.
I don't know, I leave it entirely up to you.
For me, my lord, any bench will do it. I don't know whether the much was reflected.
Oh.
Out here, it showed as partnered before Justice Arun Dev in 5th March. Then is he dealing with this case? Partnered, so will let it go to him.
I prepared. This was for.
You might have prepared, but then it would not be proper for me to take up a matter which has been heard.
Fine.
already.
That's fine.
Another chance to take another set of keys. Is joking on the lighter side. I'm ready to do it. There's no problem with me.
My learned engineer said, the minimum wages act is no more there. The code of wages act has come.
The Minimum Wages Act.
Code of wages act has come. Certain provision of the minimum wages has been wiped out. There is no more. That's why I have checked yesterday.
I don't know, this causeless.
Yeah.
No, I've not seen anywhere where it says partnered. Our only thing is that this-
For further
Normally,
for further
nowadays,
hearing, that's why it is come on part of.
normally the court doesn't want nowadays to put in a partner.
correct, we
They
don't
find
want.
it difficult for partner.
But out here, this order 23-2 says heard Mr. PIDA, Learned Counsel for the petition, not the UDIDA, at length. This is the matter on film for further hearing.
That's why that it's come for part.
That's why it says partner. Now, I don't know. I'm ready, but then I don't know if it will be proper for me to. What do you think? You want to do it before Justice Arun?
No, Lordship, I have no any choice. Let's say, no any.
What is the issue?
The issue I'm telling you, Lord, is very interesting. We are the workmen on a tea plantation. So there is a provision on the 27 of the Minimum Wages Act. That says 1948, that says the government has got this power, add to the employment in the schedule, the government has got the power. Suppose
To do what?
employment in plantation, employment in industry, this power has been given to the government. But whether there's the proposition, where the government has got the power to categorize those workmen. Now, 2015, they categorize. They categorize and they said these workers are semi-skilled workers. So that was put to challenge. And we said that 27 doesn't empower this government to categorize. Government can add to the schedule, but not categorize.
Who will categorize?
Categorize, my lord, these are the industry will categorize.
The employers.
Yes, they will categorize. That 1950, there was a Setia commission. They decided these are what will categorize unskilled. These are unskilled. They come bottom of the ladder, unskilled. Now there is one judgment, direct judgment of the Supreme Court in 2019. When it was moved by law in 2015, the judgment was not there. And it says that it is not a government cannot do. There's a direct judgment on it. Now the what interesting. Now Code of Wages Act has come in 2019. There are few projects like Minimum Wages Act. Who will fix it? It will be fixed earlier under Section 3 Minimum Wages Act by the government. This is the amount which will pay. Procedure is under Section 5. Procedure committee will be formed. They will fix it. Then they will say this is the amount. Objection, if there are some objection, they will notify the gazette. This is going from 1952 onwards till 2023. It's going on. They get it. It is again. There is a difference in Barat Valley and there is Brahmaputra. There is a difference of Minimum Wages Act. They said, why there is a difference? Why the workmen are paid less in Barakpally, why they are paid more? That's in the commission report. But the what issue,
No, but then the question is, the Minimum Wages Act only provides for the minimum wages.
only minimum.
So it depends upon the employer, they can make it higher than
Yeah.
that. Only thing is that the base value cannot be
It
lower.
cannot be lower. So time to time, there is absolutely, there is no problem. The problem started in 9th of June 2015, when they issued a notification by the government. And the government says, under section 27, we are empowered to categorize the workmen as a semi-skilled. That was put to challenge by us. I said that the government, you don't have the power to categorize. You have the power under the Act 27 of the Act to add to the schedule of the employment. You have to, certain industry, it is not been added. Government has got the power to add to the schedule of the Act. That's the whole issue. Now Code of the Wages Act, that has been removed now. Schedule the employment is also not there. A very small issue and it's been decided by the apex court. If your lordship wants to take up the matter, we are ready, we are prepared.
No,
Well, I have no obligation.
I've got some hesitation.
No, it's okay, fine. Then my lord, your lordship will,
If you hadn't brought this to my notice, then maybe I'd have heard it. You
Well-
should not have, you should have just started off.
no, it's okay, fine. Then my sister.
You should have started off, and then I would have been ignorant of the orders part. Your job done.
I am formed in any bench will.
Mr. T. Das, General Senior Counsel appears for the petitioner, while Mr. K. Gogoi appears for the state,
No, one and two, lordship.
for the respondents number
One and two, lordship.
1 and 2. Okay. It has been brought to the notice of the court. The order dated 23/2/2024 and the cause list dated 5/3/2024 has been brought to the notice of this court. The order dated 23/2/2024 passed by Mr. Justice A.D. Chowdhury is to the following effect. Just take it, okay? Put it down. Then the cause list dated 5/3/2024 relating to the court of Mr. Justice A.D. Chowdhury shows that the present writ petition is a part third matter. And that was the matter. I was ready to place this case before the appropriate bench.
In this case, for a lordship, have a look at the last order. There is some technical difficulties on that day. There is a
Last order.
15 to 2020.
Yes.
By which one of the instruction was given to the, Mr. Gautam Chaudhary is there. Now earlier he was representing for the, initially he was representing for the private respondent, then he was again representing the Westport Development Authority. So there was a clash. So court directed him to, as he is representing the private respondent 7, 8 and 9. So the Westport Development Authority to be informed that he cannot be represented. So
It's good. So what is the issue here?
issues by that day, I was served with one of the notice, demolishing notice of my factory and my lot, by some.
Let us see your notice, where is this page?
This is in my lot. In page number. That is at 31 at Annexure 10 of the petition 1768.
1768. Give me 1768.
No, 1788, my.
1788.
Yes. First,
I'm for 170.
first one,
Page 31.
page 31. Where my the demolition notice that was so-called was issued under the provision by the notification, GOV notification number dated 25/10/77. So on the basis of that, I given a reply, and ultimately by
Just a
Excel.
minute. Notice was given to you on 30/3/2018.
Yes, sir.
You have illegally made a construction within the area of Tezpur master plan. It was not by special consent, so without permission. So that was stop the construction. Stop construction. Notice to stop construction.
That was my merely.
So it is not demolition, Mr. Council.
No,
It says to
initially,
stop construction.
initially not
No,
demolition.
no, but then see, you have
Well,
got to, you see the notice
Yes,
is not for
it is
demolition.
issued- Notice was issued, and why action should not be taken under this?
Where is your reply to this?
Yes, sir. And I filed a reply.
Page?
That is in annexure 32 at page, and annexure 11 at page 32.
Reply dated
Dated, my lord, 16/3/2020.
16/3?
16/3/2018.
So you submitted an application for for being given the permission.
Yes. And they, as they did not satisfied on this my reply, then by another, my lord, the notice, it is annexure 12 at page 40.
Page
They
40.
41.
Yes.
Given me, my lord, 3 days time to demolish the construction. Actually, that construction was completed in 2016. And every operation was done in 2016 also. Factory was started 2016.
Factory, what factory?
It is an ice factory.
Building constructed
2016, everything was complete.
in 2016.
Yes. With the trade license was obtained in 2016, then industry registration also 2016. So everything was 2016, but they stated to stop the construction. By this time, the construction was completed and
Is
after,
the trade license an industry license?
yes. Food safety license also I got. Everything was valid. But subsequently, by
Oh,
this-
in 2016, everything.
but
Just
subsequently,
a minute.
by this notification, this demolition notice, annexure 12 at 40, I was given the ultimate
You cannot do this.
to construct to demolish the construction within 3 days. Right? So against that matter, I approached before lawsuit. This first thing. And whenever my lawsuit took the matter, the direction was
This lawyer, he wants to appear by virtually, he's moving in a car. He's moving in a car and wants to.
because
This is not done.
there was a case like this in Calcutta, madam.
This is completely illegal.
Yes, it can be.
We cannot achieve,
Yes.
he's in the car.
Yes.
And try to do his case to start.
We cannot be.
Remove it.
Except hospital, we have no for any other. Not even hospital. In fact, there was a case, reported case in Calcutta, my lord, where somebody was doing this type of kind of video conferencing with car, my lord. And lawsuits have taken a very kind of strongly that this does not have been done, my lord. That was happened to Delhi also. That is Supreme Court in a case of the one senior advocate was in a hospital. That was considered from allowed to submit for judge. So when the matter was taken up at lordship, direction was given to produce that notification because I
No, just a minute. You are the cultivable land.
my lord.
Power totally.
Yes, sir. Is a low.
Okay, so their case is basically, you have made construction over power totally land. which is only for cultivation purpose. And that's why you cannot make the construction. So this is the page 40 is the notice to demolish construction. Where is the reply to this?
My lord.
Reply to this.
But after that,
Page
I
40.
did not have any reply, my lord, because I approached 44 by the minister.
Okay, so you challenge this.
That was stayed and the direction was given to the authority concerned to produce that notification because I challenged that notification was no longer was there.
That notification,
Yes,
that will be
77
about only land.
notification was no there. So they failed to produce,
Ah.
repeatedly requested, but ultimately they came with a notification in 2010.
Then,
2010,
then,
2010 notification. Instead of 77 notification, they came with a notification 2010. Union planning plan notified.
how does it matter whether they bring a 2010 notification? How does it prejudice you?
Well, the initially the notice, well, that was issued on the basis of the 77 notification.
Oh, okay. That page 31.
Yes, my lord.
Just let me see. By violating the verse 13:1. No, it does not say 77 notification.
Yes, my lord. Kindly see, my lord. It is hereby informed you that you have illegally made a construction within
Okay.
area Tezpur master plan, which was brought by Assam Crop Notification. That is 15/10/2077.
Dated 25/10/17.
Actually, there is a printing mistake, my lord. That is a 77. My lord.
Let me see this 77 notification. Let us see the 77 notification.
No 77 notification is there. My lord. That is the case. So
Okay.
whenever take came with the 2010
This is the translated version. Where is the original?
original, my lord, I got, my lord.
Huh?
Yes, it was notification.
We will not hear that item 7. I'll pass it on, huh? Huh? I think he's for the petitioner. I don't know, some of these persons have got no sense of propriety.
The other day also in that case, I was telling my lord the manner in which my lord you had spoken to. That I had applied your lordship and lordship says that he actually gets to learn. So my lord, sometimes further some workshop also to be conducted here, see my lord, at least teach their propriety.
Yeah.
If this is the relation between the bar and the bench, that levels to maintain.
Correct. Now, if we allow that, okay, maybe a private car, someone will do it next from a taxi
Yes.
or,
In the Calcutta.
or maybe while having chai in some shop or something or
In the Calcutta case, it was a taxi ban.
taxi.
Taxi.
Yes, where is the original?
My lord. Someone is here, my lord.
Okay, is page 31. Is it denied? Since 1977. Is
Yes,
notice.
my lord.
My
How
lord,
does it
Huh?
matter?
my lord, my lord. Thank you, my lord.
No, please, I'm asking him.
No,
I'm asking him. Please,
my lord,
I'm asking him. Let me talk to him. Or should I talk only to you?
not my lord.
Then let me talk to him also.
But he is representing my lord private.
That's what. So can't I ask him? Can't I?
That is being given by
Mr. Council, can please let me do my job? You do your job. Okay. Yes. Let me ask him. Yeah, this 77, he says this notice, page 31, is it denied?
No, this is not denied, madam.
The contents are not denied.
No, notice is there, madam.
What is there?
Notice
So,
is there.
so this
But then,
notification that is been mentioned,
my lord,
25/10/77,
my lord.
in this notice is also not denied.
No, my lord.
It's not denied. Okay, then it's okay.
What happened, my lord? What happened is,
No. Yes.
what I'll explain, my lord, what happened? My lord, these are government authorities, madam.
Ah.
They have a cyclostyle, my lord, with letter pads,
Uh-huh.
and they continue to go on using it, madam.
Perhaps in that manner, this 77 was inadvertently, my lord, it has crept up.
Uh-huh.
But when it is being proved, if the lordship is the last order, my lord, the 2010 notification was, my lord, he challenged that also, saying that there was no notification and that regulation of that master plan was not, my lord, properly advertised and all these things. Then, my lord, the government came up with a document and lordship has accepted that. And when in the 2010, my lord, that particular area where the construction has been made has been proved to be within the master plan of the Tezpur, my lord. So the question of, my lord, getting a permission from some Gram Panchayat, my lord, and
Doesn't
thereafter
arise.
from Gao Panchayat, and my lord, doing this, my lord, it doesn't arise. And thereafter also, if the lordship sees the reply which he has given to the show cause, there he seeks, my lord, apology and forgiveness.
He
my
wants
lord.
application, he
Yes,
wants
my lord.
permission.
And overall, over that, my lord, one is that he does not have any permission, my lord, from the appropriate authorities, knowing fully well the permission was required. And the second is that he has made this construction over Bautoli land where there is a statutory bar, my lord. Over agricultural land, you cannot do it, my lord. This is statutory. That's the thing, my lord.
Yes, it appears. Okay,
77
so we leave that. We accept that there is, the notice has said 75. So then they brought out the 2010 notification, correct? Where is the 2010 notification? It's not in the affidavit. Page? There, okay. 25-1. 25-1. Then, uh, a notification bearing number of the sensor dated has not been reflected. Eighteen, 12, 23. Just a minute. Ah, 24, 11, 23. There's a notification. So now the issue is whether his land comes within this master plan area.
In that second page of the Gazette lordship sign on the left page, my lord,
Yes,
there is,
this one.
yes,
Huh.
there is one place in the second column perhaps, that is Vidor Suki.
Huh?
Second column. After item number 28.
Bhairab part, yes.
28, 27 of
Vitar Suri.
because that
Vidor-
his land, his building was constructed in that Vidor City village,
Okay.
which is under the master plan. That is why it requires permission. Without permission, we cannot.
And where is the statutory provision regarding this Bautoli land?
Deepika, my lord. Assam Agricultural Land Regulation and Classification Transport for Non-Agricultural Purpose Act 2015. Section 3, ma'am.
It can be only used for house, dwelling house.
If at all permitted,
It would be permitted. Yes, now you can start.
My lord, if my lord, my part is concerned, my lord, they said that I am the constructed three house like that, like, because then constructed by the houses, it's to be constructed, three houses. Then my lord, I came to my, that is three people. This is not my, the first, my lord, the only construction that I have made. The entire land is a huge area of land, which under the same that same
Is it under this village?
village, my lord, yes. And it's not only that, the government construction also there, one market that is by annexure, one.
How do we know that this land is Bautoli land?
actually, my lord, has been stated there, my lord.
Where in the Gazette notification?
No, not in the.
No, then
Gazette notification.
Gazette notification is only with regard to
Yes, my lord.
what area comes within the,
My lord.
that master plan.
That is more or less admitted because he has also never, my lord, challenged that.
No,
it is
no,
not about.
no, the issue is basically whether it's Bautoli land or not. Because if it, you see, one thing is that, if it is, if it is within the master plan, okay, permission has to be given. He can always apply for permission, even if it's late, he can always apply. But if it is Bautoli land, of course, then naturally, the law does not. So the question is, if it's Bautoli land, there's no question unless it's reclassified, and which cannot be done. The other aspect is if it's within the master plan of the Tezpur, whatever, master plan, then permission is required from the authorities for building. There is no bar. Only thing is permission is required, that's all. Isn't it?
My lord.
But
Then, my lord, that should be applicable to all.
naturally, but you
So,
see,
so kindly
they don't catch, you see, the problem is, in this whole world, there's so many violations. Say even in criminal law, there's so many thieves, there's so many murderers, there are so many cheaters. They don't catch everyone in the world. Unfortunately, they caught one.
But law should be equal to all.
Law should be equal. It is applied equally, but they don't catch everyone. They don't have time to catch everyone.
Why don't they see the
One is enough.
construction carried out the government also when it's query.
Ah.
Whether it is for and put the power to the.
Ah,
Is accepted by the pilot, by the.
Like,
Instead of the.
38.
it is, I agree with that, but that is construction minus before that, minus it's in 66. There was no cultivation activity was there.
No, Mr. Council, the issue is, once it is Bautoli land, when was it declared Bautoli land?
That is why initially land was belongs to one about it.
No, it-
That is time of purchase also.
So, now this act is of 2015. So prior to 2000, and you completed 2016.
Notification was, that notice was issued on 2018. This is 2 years back, after my. My completion of everything was it is not that I, only by constructing the building and I started the business and industry, my lord. It is observing all government procedure and formalities. And I obtained the permission from the, my lord, Tao Panchayat, because as per my case, the land at that time was not come under the development. Authority.
Okay, this agricultural act of 2015, it is in supersession of what? Another act or what? It's a new act.
Earlier also, my lord, there were there.
When did you start your construction?
16, I have completed everything.
When did you start?
That is 16. Kindly see my document, my lord. All the documents are there.
Right?
It is started from.
Oh.
16, my lord. 2016,
Just a minute.
that was, my lord, by execution of a court order. That land was given to me. It is not that I had certainly go.
Court order dated?
That was back, my lord. Before that, my lord, I was given.
Court order dated? Purchased the land in July 2015.
Yes, July 2015.
Ah.
My lord, that was,
Just a minute.
that was.
I just want to know when the law came into force.
But in their notification, they relied 77 notification. So my case was that when it is 77, there was no such of notification, and that in media was not under the successful development authority.
Mr.
That was
Council, a mention of a wrong provision of law does not, does not vitiate, does not vitiate an order if the power is there.
My lord, my humble submission, my lord, if the notification was or any notice was issued under some wrong provisions and everything, and any subsequent action taken on this, my lord. it is-
Mention of a wrong provision or non-mention, mention of a wrong provision does not mention.
My case was humble submission. From the very beginning, my lord, I stated that there was no such notification, and basically they were asked to got this notification before the court, and they also don't deny that due to some wrong and mistake, that was notification and that mentioned as a 77 in their agreement. They are saying that the notification was there, and ultimately they got the notification 2010. And same notification also, it is only the area was mentioned. Whether that particular land is kind of excluded within the area or but it's included.
You yourself have said in your
Initially-
paragraph,
Initially, that was
the
there.
classification of land has been shown as
That is true. I am not.
since
I am
1966.
not hiding anything, my lord. Kindly see the annexer one. Kindly see the-
Maybe
kindly
you
see
see,
the annexer one.
because you're not hiding anything. Now we are not
No.
we're not going to go into disputed questions of fact because there's nothing disputed.
Well, my that area, that construction is not the only one construction there.
Ah.
The entire area has been constructed and.
So now you file PIL against your neighbors.
I not, I am not going to that, but if any PI will come, it will earmarking that area is a specialty, is a.
Mr. Council,
And one of the government, how allotted the land to the person.
Mr. Council is like this. Supposing just I am to decide whether you are a lawyer or not, and you say, and he says you are a lawyer, and you say you are a lawyer. Then initially, what should be my reaction? That you are a lawyer. I should agree with you. Unless there are some other documents to show otherwise. Now, in your repetition, you have categorically stated that this land is Bautoli land. Then what is there?
Yes, but moreover, I am saying that there was no such notification including got this land under this development authority in 77.
Maybe, but 1977, you are not the owner of the land.
77, I was not the owner, but thing is that after that, my lord, lot of construction, not only that, this before that, my construction,
This act came into force when? When?
No, act is come 2059, my lord.
2015, correct.
Act is came in 2059, sir.
59?
Yes, my lord.
No.
No, 1959, my lord.
Huh?
1959, this town and country plan, my lord, that is act, my lord.
It's not aware of it.
It is, my lord. It is 1060. Yes, my lord, 59. Assam Town and Country Planning Act 1959.
No, I'm not on that. I'm in the agricultural.
The agricultural land, my lord. That is, my lord, I think,
205. This is 2015.
and government itself also, my lord, constructed, my lord, the own market and everything in the same land. If the government is also, my lord, indulging the construction of their own.
No, we'll catch them also.
my lord,
We'll catch them also. What to do? What to do?
I should be equally treated, my lord. If the construction, government construction is given there, and there is no objection in going on the government construction and the other settlements, then why they have any objection regarding me? We can choose why.
There's no pressure of pickage. You see,
Yes,
pickage,
my lord, I am taking the plea.
we are taking the plea. So what to do? Like I told you, all the criminals in the
No,
world
my-
cannot be caught. All the bad persons in the world cannot be caught. All the persons who flout the rules cannot be caught. Unfortunately for you, you are caught.
But that is not their pleading, my lord.
No, it's not a
Pleading sheet
question of
there.
pleading.
No, that is, if the pleading sheet not there, then how that can be relied on that, my lord? reading must be there that this is the case.
No, 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 no. Sorry,
Yes,
sorry.
my lord, my case is this, my lord, the notification is good on the basis of the notification with demolition notification 77. And how they came to jump and saying that this is 2010 notification. Then they have to issue the fresh notice on me on the basis of the same.
Sorry,
provision.
sorry. You can go to the DB.
So, my lord, my case is, my lord, kindly, my lord, have a, my lord, kindly have my, this, my lord, kindly, allow me to submit. My lord, this property, my lord, the other construction, I annexed, my lord, everything. And my construction is not that I have started my own. It is after the.
It is like you saying, it's like say, a murderer saying,
No,
oh,
but
you
this
have,
way-
no, no, I'm not talking about you, a murderer being caught. Like, oh, why have you caught only me? There are so many murders all around the world,
No,
even in Africa, even in America. Why are you catching this poor Indian here?
no, but,
They cannot catch everything, everyone.
but you think that.
That's the life.
My submission is this, but if some construction is going on illegally, that is within their knowledge, my lord.
We don't know. Sometimes
If,
you
why
see,
they have not.
murders also caught usually after the murder, not in the process of the murder.
I just kindly have a look at my annexal one, please,
Initial one, okay.
this page.
Yeah.
It is self as portion, my lord. At next, my lord, is 21.
Huh?
21 self as portion.
Yeah.
Where, my lord, is, and you see, my lord, today on substances is Sri Prafulla Boda, President of the Sinipur District Council, in presence of the Rajan Gorthaka MLA Tezpur Legislative Assembly, laid the foundation of stone of the daily market of the Ropur Sagali under the financial of 13 financial.
Yeah.
It is same here. It is adjacent to same. I am
You see, Mr. Council, there are many things that could have happened prior to this. The land for classification could have changed. Permission may have been taken from the authorities to construct the market. So we don't know those aspects. In your case, unfortunately for you, we know the case. Now this MLA laying a foundation stone for the market in the same area.
adjacent to my code. I am
yes,
declaring
yes.
code I am sharing.
Okay, it appears to be illegal prima facie. But we don't know because their case is not before this court. In their case, maybe permission had been granted. Land may be reclassified because this law provides that your land can be reclassified.
That can be valid.
Then-
So, but that opportunity may be given by.
You go and ask, that's not a problem, no bar. But right now, you see, right now, the case before this court is whether the decision taken by them is correct or not. That's all. We're not going into the reclassification. You are saying that it is incorrect. But then, as it is, it appears that there's nothing wrong. That's all.
No, that is not wrong, but I am not saying that. But he gets a so far notification, they mention that it is wrong.
Okay, that I will take care.
So, but on that notification basis, but they cannot take any action on.
Okay, that I will take. Yes. Okay. All right,
But
Mr. P. Mahanta.
one aspect. I have started the industry. Not that on the basis of the all documents required before starting the industry. So everything was completed before starting the industry. And that was completed in 2016. And they totally silent over the entire issue during that year. So whenever the entire exercise was done and 2 years also continuing, then suddenly they came with this notice and saying that you have constructed illegally, so that's it. So my case was there, one of the before issuing the that notice, floor board and demolition notice, entire operation was starting in 2016. And that is not that it is all government document assistance. From the industry, right from the industry and from the matter Dow Pansat, because they were authorized at that time giving the permission to that area. And they have issued not only to me, lots of pilot permission are granted by the Dow Pansat for construction and getting into construction.
You can apply to the authorities. There's no bar. But right now, the issue,
Going on, my lord.
Mr. Council, the issue is very simple here. The issue is
So my
whether the decision of the government in issuing that order is correct or not. That's all.
mine will be given an opportunity to approach the minor the authority so that
No one is saying don't go. This case was filed in 2018. So you have had 6 years to go.
No, my lord, there is a stay order by the honorable court.
Yeah. So it doesn't mean that stay order is there that this stay order should continue till kingdom come.
No, it is not that ultimately that will be decided by your lordship.
Right, third,
But if
Mr.
you
P.
say lordship
Mahanta,
is by then,
learned counsel for the writ petition. Also heard Mr. S.S. Roy, learned counsel for the respondent number 1, 2, 4, 5, and 6. And Mr. A. Barwa for respondent number 3. Mr. G. Chowdhury appears for respondent number
7 and 9.
7 and 9. The petitioner's prayer in the writ petition is to
Hello, but I pointed out one
set
point.
aside
Another institution also,
the
that was I have challenged you that subsequent of
birth certificate.
that 2010 or it was instead of 77, they brought it around 10 or so. So next institution also I challenged that. Okay.
On what ground are you challenging it?
Because they failed to got this certificate of find this certificate. Okay, that was
Right.
Second,
Then, give me the other writ petition also. Yes, fine. Outside there's so many writ petitioners. Yeah, for 7, 8, Mr. Chowdhury.
he implemented letter of life. I was implemented letter of.
Okay, you are from 7 to 10.
Right.
Huh? What have you said? No, 7, 8, 9. In WPC number 7 to 10, sorry, not 7 to 9. 7 to 10. In WPC number 1788/2008. Oh, sir. Next para. In WPC number 521/2023. Comma. Wait. Before that, from the beginning, you're right, huh? Mr. P. Mahanta, he appears for the petitioner, writ petition in WPC 1788 of 2018 and 521 of 2023. Writ petition, not petition. Mr. S.S. Roy appears for the same, I think, same. In both the writ petitions, huh? Both the numbers, in WPC census and census. Then Mr. So also, who? You are appearing for who in the first writ petition? Three. Same, huh? For both. Okay. Then who is appearing for the Gal Panchayat? No one.
Very interesting you are taking.
Right. No one appears for the respondent number 7. That is the Dolabari Gal Panchayat in WPC 521 of 2020. Next para. The two writ petitions are being disposed of by this common judgment and order in combined as much as the issue pertains the issue pertains to both the writ petitions. The issue to be decided pertains to both the writ petitions. Next para. In WPC 1788 of 2018. The petitioner has paid for setting aside the notice to demolish the petitioner's construction, petitioner's buildings by notice dated 19/3/2008. In WPC 521 of 2020, the petitioner has paid for a direction to be issued to the state respondents not to implement the Gazette notification dated 24/8/2010, publishing the revised master plan and zoning regulation for Greater Tezpur dash 2013 or 31. 2000.
It is revised master plan in 2010, it's still 2031.
To 2031, dash 2031. Which is the basis for issuance of the notice to demolish dated 19/3/2008. Stop. Next time. The petitioner's case is that the petitioner is the owner of land measuring 7 bighas, 1 katha, 10 lechas out of total land measuring 28 bighas, 2 kathas under DAG number 145 bracket N, covered by PP number 45 bracket N in the revenue village Vita VITAR SQTI VITAR SQTI in the district of Sonitpur. The classification of land has been shown as Bautali, that is low agricultural land. Pusta. The petitioner, however, the petitioner's case, further case that since 1966, no agricultural activity has been done over the said land. Pusta. The petitioner had purchased the aforesaid land in July 2014. 2015. 14 would have been better for you. It would have been prior to the act.
Actually, purchase was done by here. This is done by the execution of the court order. I purchased along that, that was not, so the deed was not executed, so I approached the civil court for civil conference of complaint. Then ultimately, in 2015, that was classified.
What do I say? And utilize the same for commercial for commercial purposes. Next up. The petitioner found something that on 13/3/2018, a notice was issued by the Tezpur Development Authority to the petitioner, stating that he had made an illegal construction within the Tezpur Master Plan area, which was brought under the Tezpur Master Plan by Assam Government Notification Number, by the Assam Government Notification dated 25/10/1977. As such, the petitioner was asked, no, as the petitioner had started construction without obtaining the permission of the Tezpur Development Authority, in violation of section 13(1) of the Assam Town and Country Planning Amendment Act of 1959. The petitioner was asked to stop the construction process and to give a reply as to why an appropriate action was not to be taken against him as per the provisions of section 30(b)(1), 31, 52 and 51 and 52. Is at page 31. Okay. Next. The petitioner thereafter submitted a reply dated what is the reply dated? Reply dated 16/3/18 to the notice dated 13/3/2018. By stating that he had constructed an Assam type house for an ice factory. Besides constructing various latrines and bathrooms for use by the general public and shopkeepers of the daily market. The petitioner stated that he was not aware that permission was required to be obtained from the Tezpur Development Authority prior to the construction made by the petitioner. So he accordingly asked for he accordingly asked for forgiveness. He accordingly apologized. He accordingly apologized for not obtaining prior permission to make the construction. Along with his reply, dated 16/3/2018, the petitioner submitted his land documents along with the forms which had been taken from his office for obtaining permission for construction of the ice factory. Subsequent to the above event, the Tezpur Development Authority issued a notice dated 19/3/2018 to the petitioner, asking him to demolish all the illegal constructions done by him. As he had made the construction over Bao Toli land, Paotoli. Bao Toli land was to be used purely for cultivation. And that construction of a building over cultivation land was not permitted without obtaining prior permission from the office of the State Food Development Authority. Next. The petitioners counsel submit that the notice dated 13/3/2018 issued to the petitioner by the respondent number 3 to stop construction activity has been made on the basis of the has been made on the basis of Assam government notification dated 25/10/1977. However, the respondents have not been able to produce the said government notification dated 25/10/1977 and have instead issued the notice dated 19/3/2018 directing the petitioner to demolish the construction made by him for the ice cream factory in pursuance to the state government notification dated 24/8/2010. 24/8/2010, no? This gazette notification. 24, 24/8/2000. He submits that as the notice was issued on the basis of a 1977 notification. Baba. No, notice dated 13/3/2018 has been issued on the basis of the 1977 notification. The state respondents would not have asked him to demolish his building on the basis of the 2010 notification. That's all I think. Next, Mr. Jaden. Yeah. A. Barwa, learned counsel for the, that's point number 3. Submit that. What, that 1977 you could not trace out. What? No, that notice talks of, the notice talks of the 77 notice. No, so this notification, now what does it aim to do? Just give the area of the Tezpur master plan. That's all. And then that all the,
The
and
power, my lord, exists under the Assam Town and Country Planning Act of 1959. The power to stop construction, or to demolish or whatever, that power is there in the Act of 1959.
so all the permission for construction has to be taken from.
Yes, since 1951 that was there. But now from time to time, what happens, my lord, with the growth in the population, my lord, the urban area is defined, my lord, and it is increased. And with these, my lord, time to time, my lord, that area has been increased. So since 2010 itself, my lord, with the revised master plan, my lord, this particular area on which he has made the construction has been brought within the fold of the Tezpur Development Authority. So, my lord, when it is brought within the fold of the Tezpur Development Authority, my lord, then the Town and Country Planning Act applies. My lord. And on the basis of that,
1959.
the power is there, my lord, and they have issued that. So that, my lord, even if it's a structural error, that wrong mentioning will not take away the power of the, my lord, government to
Correct,
issue the
correct.
notice, my lord.
But think it about it, the area is broad, final, the area is not at a without specifying the gas, supply and everything, well, the at least part of the boundaries should be there, it's a huge area. How they can say, well, this land particularly comes under. the-
Mr. Council, that is what kind of a argument is that? That's not argument.
After that,
When you see the village area is there, village, you come under the village, that's
No,
all.
well, the revenue record.
His area is identified.
No case.
The
Sorry.
revenue-
Sorry. I've heard you on that. Just clarification.
But if I have to submit a pilot, whatever my government, these are really submitting pilot, he has no right, local state to stay on this pilot, because pilot, he has pilot stranger. So subsequently, he entered in the land, on what basis pilot he entered, I don't know.
He's only helping the court,
No,
Mr.
pilot,
Council.
only basis of his pilot, representing his flight, 7 to 10, they were the private parties pilot. And they have no right to say anything on this issue, because everything has to be.
I will not record any submission of it.
That is up to you, pilot.
No, since you don't want, you're saying he has got no right.
There, my lord, the 77 notification they have paid. So if the 77 notification is paid, then notice itself is a minor plan.
Only thing is, Mr. Kaushal, why can't you consider his case for reclassification of the land? So that boundary land can be reclassified also.
Just for development, it failed to pilot to realize the consequence of this order. If this order is with pilot pass, how they will face, but if somebody will come with a PI, lots of construction, even they having interest of the construction, that will go. Even the BJP parties office also there.
Mr. Council,
That will go.
you see, I am only here,
Chairman is given by.
Mr. Council, I am here only to interpret the law.
That is true, my lord.
I,
Failed to realize.
what happened because of the decision taken is not my concern.
That is true. But consequence will be dangerous. Sir.
Maybe consequence, let it be dangerous, so what?
So what not then
But we have got to go as per the law.
then litigation.
Just because the law is, just because the law says,
They have to face my.
just so what?
New methods will come, it will be good for us. My lord, we have to say, we'll have some windfall also, my lord.
But what to do?
We can choose manner, my lord. This is very unfortunate.
Unfortunately, like I said, some thieves, and even you're cheating in an exam. The only thing you've got to ensure is that you don't get caught. Unfortunately, for those who get caught, I have had it.
My lord, Assamese, my lord,
Ah.
Assamese vernacular language, there is a saying, my lord, everybody will know here, my lord. It says, my lord, that Turi Vidya, he is a Mohavidya, my lord. What, my lord, once you get caught, then you get snared by, my lord. It is stones, my lord.
Unfortunately, Mr. Council, what to do? They cannot catch everyone. You're unlucky, you got caught. Can I say that since you have violated the law along with 20,000 others,
I am
that even if I catch you, you should be set free. Is that what you
I'm
should
not
say?
saying that I am.
Then no one will be in jail also.
What why I raised the construction here. This is what my first. Before that, kind of the government has raised construction there, their own markets also. They are running market. This is tender basis is happening every year. So entire area was under construction.
We do not know. Permission might have been
No,
given.
my kidding, sir.
No, permission might. They are not parties here. Those persons who are running the shops, they're not here as parties. This is not a PIL.
Why this private respondent
No, I think we are wasting time.
only one guy.
Yes.
It's the matter I saying that.
Yes, sir.
Only the block
Yes.
will go by the order. I'm not.
Yes.
But before the ballot, because by not they were the person, they might not want to purchase, well, they dispute land between the by me, my land, this person and the respond, private respondent. Whenever I got the final order from the court, by virtue of an execution case, then they jail up and they kind of came with the implemented in this along with this one and the entire investigation has been done there on the behalf by the case. Entire investigation. This is the thing. That is why I have been my lord.
They are politicians.
Yes, my lord. And the case, my lord, I have in my but whenever they bike in
The election is coming. Don't vote for whichever party they are for.
Yes, my lord. And the all construction this is been going on under the permission of the development, not development authority, it is Gao Panchayat. I am humble committee. And Gao Panchayat also giving the if it should have that effect. But then we are giving the permission. So this is fine.
All sympathies for you, but I have to go by the law.
But the that to be consideration will be taken into because the Gao Panchayat say that they are the authority. The affidavit also there.
I cannot go by what they say. I've got to go by the law.
Why humble submission this notification refers to 77?
I've heard you, Mr. How many times did you? If you say it to me 1,000 times, it'll go more deeper or something.
No, that's why I'm not.
Then right, whatever I said, last sentence. Submit that. No, before that, what did he make any submission? No. Submit that. Uh, though the notice dated 13/3/2018 may have referred to a 1977 state government notification, comma, there is no infirmity with the state respondents taking action on the basis of the 2010 state government notification, which provides that the area in which the petitioner has constructed his ice factory is within the master plan, the revised master plan for TESCO in terms of the notification for TESCO. He also submits that in terms of section 3 and 4 of the Assam Agricultural Land Bracket Regulation of Reclassification and Transfer for Non-Agriculture Purpose Bracket Close Act cover 2015. There is a bar on use of agricultural land for non-agricultural purposes, without reclassification being made by the competent authority. Without reclassification and permission being given by the competent authority. That is the Tezpur Development Authority. Okay, I will not record Mr. G. Chaudhary's. I have heard the land councils for the party. The pleadings in the writ petition make it clear that the petitioner had purchased the land in which he has made the ice factory only in July 2014, and that the said land had been classified as Bautoli land, that is low agricultural land. Pusta. This is reflected in para 2 of the writ petition. Pusta. Next para. The 2059 here and after referred to the 2059. na? Section 3 of the 2015 Act provides that no person shall use or transfer agricultural land for intended non-agricultural purposes without reclassification and permission in the manner mentioned in section 3 bracket Roman 1 small to section 3 bracket 4 Roman small 4. Section 3 bracket 4 of the 2015 Act provides that no permission is required to be obtained from the Deputy Commissioner when an agricultural land not exceeding 1 biga is intended to be used or transferred for construction of one owns dwelling house when the same is limited to 2 stories. In such cases, the Deputy Commissioner may suo moto or on an application received from the owner or the transferee reclassify such land into residential class. Pusta. Section 4 bracket 1 of the 2015 Act provides that an agricultural land which has become unfit for agricultural purposes or no agricultural activity has been done for at least 10 years preceding the date of application for permission, shall only be reclassified or reclassified transferred for intended non-agricultural purposes with the prior approval of the Deputy Commissioner. Pusta. Section 2, next para, section 2 bracket Y defines reclassification to mean change of land use from agricultural purpose to intended non-agricultural purpose, and reclassified land means land for which permission under this act is granted for use for non-agricultural purpose. The above provisions of the 2015 Act clearly show that there is a bar on use or transfer of agricultural land for non-agricultural purposes, unless reclassification of the land and permission for the same is obtained from the concerned authority. Section 2 bracket Y Section 3 and Section 4 of the 2015 Act is reproduced herein below as follows. In the present case, there being no dispute with regard to the fact that the land of the petitioner in which he has built the ice factory is a agricultural land. It is also not in dispute that the petitioner had not applied for permission to construct the ice factory in the agricultural land. It is also not in dispute that the petitioner has not made any application to the competent authority for reclassification of his land to a for a non for a no for non-agricultural uh, for non-agricultural purpose. The above being said, comma, the notification dated 24/10/2010, published in the Assam Gazette dated 31/12/2010, has notified the revised final master plan for Tezpur. And the same shows that the village Vitarsuti, Vitarsuti, in which the petitioner's land is located, is included in the revised master plan for Greater Tezpur dash 2031. In that view of the matter, comma, it was necessary for the petitioner to obtain necessary approvals and permission for construction of his building, for his ice factory, from ice factory and other construction from the Tezpur Development Authority in terms of the Assam Town and Country Planning Act of 1959, read with the Assam Town and Country Planning bracket publication of master plan and zoning regulations close rules 1962 and its amendment and subsequent amendment. Next. With regard to the contention of the petitioner counsel that the state respondents could not have applied the state government notification dated 24/8/2010 reclassified, no, which classified the revised, no, which notified the revised final master plan for Tezpur, comma, as the notice dated 13/3/2018, asking the petitioner to stop its construction work had been done in terms of the Assam government notification dated 25/10/1977, comma, this court is of the view that the said submission does not hold any water. The reason being that the Assam government notification dated 24/8/2010 covers the case of the petitioner. And there is no requirement, there is nothing, and there is no reason for this court to go against a policy decision of the state government wherein the state government has notified the areas which would be included within the revised master plan area for greater testing. This, the notification dated 24/8/2010, being purely an administrative exercise which is not violative of any fundamental or legal right of the petitioner. This court does not find any ground to set aside the said notification. So stop. Next paragraph. With regard to the petitioner's counsel's submission that the notice dated 19/3/2018 issued to the petitioner to demolish his construction would not have been passed as the earlier notice dated 13/3/2018 to stop construction had been made on the basis of. Wait, no, just read that. Issued to the petitioner on the basis of the notification dated 24/8/2010. Comma. Two. Repeat. Carry on reading. Could not. See, it could not have been issued. Issued. Could not have been issued due to had referred to the government notification dated 25/10/1977. He submits that when the earlier notice had referred to the notification dated 25/10/1977, which has not been produced in the court, the subsequent notice could not have been issued on the basis of a different notification. This court, no. On considering the submission made by the petitioner's counsel, this court is of the view that when there is a power, when there is a, when has no, this court is of the view that it would be with regard to the above issue, it would be profitable to refer to the judgments of the Supreme Court in the case of Dash versus Dash. Tulsidas and not Tulsidas versus Union of Christians, wherein it has been held that power must exist for its exercise. Tulsidas. No, anyway. Further, in the case of Dash versus Dash, the Supreme Court has held that the Supreme Court has held that mere mention of a wrong provision of law does not reshape the order so long as the power exists for its exercise. In the present case, even though the earlier notice dated 13/3/2018 had referred to the state government notification dated 12/1977. This court does not find any infirmity with the exercise of power by the state government in terms of the the notification dated 24/8/2010, which has been notified in the Assam Gazette on 31/12/2010. Further, no, no, further, there is the action of the state respondent is in conformity with the 2050, the 2015 Act, with the provisions of Section 3 of the 2015 Act. 3(1) of the, no, Section 3 of the 2015 Act. As such, this court does not find any reason to interfere with the impugned notice dated 19/3/2018. The writ petition is accordingly dismissed. The above being said, the petitioner is given the liberty to approach the respondent authority for reclassification of the land in question for the purpose of allowing him to use the to allow him to build the ice factory and other construction which they will decide as per their discretion. As per your discretion, you know, as per their discretion and as per the law.
And till then, my lord, no purchase will be taken. Another day, now for the. But this proposition will be given.
There's no question. Your thing is illegal.
No, no, when the question, no, but hospital was when they approach to approach the authority for.
The question of allowing the petitioners to continue with his ice cream factory should also be prayed before the authority concerned till a decision is taken by them. We take it before the authority. Okay. It's on discussion. The petitions are accordingly dismissed. Acha, one thing you write, huh? Petitioners council submits that prior to commencement of the ice factory, the petitioner had applied for trade license, industry license, and food safety license, which had been given to him in the year 2016 by the concerned authority. Nothing. Here's the arbitration. Let him come, he will there, this he's for the one who has it virtual. This is the council, what is this? Your colleague, your senior colleague in a car, trying to appear virtually in a car, we are seeing him traveling in a car. It's not done. No, you please tell him. What does he think this is? Next time probably he'll be having Bhelpuri and trying to appear this court. It's not done. Please tell him. Yes, sir, what is to be done here? No, there was some confusion regarding the petitioner, my lord. Yes. The contract was executed, the contract agreement is page 29, my lord. Is between the railways and gates. Okay, right, just right. Heard, Mr. R.A. Chaudhary appears for the petitioner. Submits that he apologizes for his senior counsel trying to appear virtually today while traveling in a car. Huh?
My senior, my colleague,
Oh, while is colleague? Mr. While is colleague, Mr.
FA,
F.K. Hassan.
AA,
F.A. Hassan.
AL.
F.A. So trying to appear virtually while traveling in a car. So Mr. H. Gupta, let CGT appears for the respondent. This is the matter after 3 weeks.
Attack authority man.
Not done. There should be some, the minimum courtesy should be shown. Minimum courtesy.
I will inform. I will. That's it. The better part is, what a story. And the before starting is that it's still part of it. What a story is well settled by several government finance. That is from optimally to have treated African construction.
Huh?
Starting from the case of Muslim Ali Vice, the year 2012 Vice. Treated after construction finance. Then for a story kept it apart. Kept it in the system just that it was just like. Now my lord before going to the case close by. Depth of the case is my lord.
Huh?
Depth of the case is that. Petitioner was a contractor. He was allotted as contractor work. Work order was issued for 17 feet 2020. Actually, it was a I am 6,500 because of my cigar. Last 3 days I was in yes, 5%. That is why I was.
So what is
It is impossible, my lord. They have to for side.
what to do? No, we can't. We've got a lot of this.
One side, my
No, no. Maybe it is. Mr. H.M.R. Mr. H.M.R. Chaudhary learned after for the petition. Submits that he is not feeling well and accordingly pays for adjournment. Mr. R.R. Gogoi appears for the foreign department. While we send the case for the PW. On the prayer of Mr. H.M.R. Chaudhary, this is the matter. Yes, yes. When? India one. Okay. There are a lot of citations. How many citations are you bringing?
four sided,
And you are bringing how many?
two sided.
Six. Which one is the latest? You have got what? DB?
Here.
DB?
All DP by
All DB and here?
my son jail here, doctor.
DB or single?
DB.
He's not feeling well.
Some of the
April. April 1st week.
I'd ordered it is 8/1/2024. Deputy Commissioner Bobra was directed to demarcate the land of the petitioner in presence of both the parties and thereafter to submit a report in the seal cover. In the last occasion, government had took it as for further 2 weeks time. That was allowed for 6 years.
But Lordship, I received an instruction that there is
Earlier.
after 8/1 or
But what is that letter dated? Letter dated?
12/3/24. That is earlier letter. That instruction was not proper, therefore, I order dated 8/1/2024. Only there is a. As per this agreement, Lordship, it says Lordship, doc number 384, 358 and 30 so and so are included in the existing bill. And it was also reported that the 387, 349 and 500 are not covered in the existing. Yes. But that direction was to demarcate the land in presence of both the parties. After, look what the order dated 8/1. 8/1, last paragraph. What specific direction was the deputy commissioner? Who made it the inquiry? I don't know. We have not given any copy. Last paragraph, tell you the copy. Accordingly, look. Last. Yeah. The deputy commissioner, have you got the copy?
Yeah.
Last paragraph, accordingly, the deputy commissioner Kolkata is directed for an inquiry, especially with regard to the area in question and as to whether the land covered by the associate pata numbers are within the notified area boundary of the fisheries in question. And that too, it is inquiry to be strictly in accordance with the law by giving scope to the hearing of the, to the petitioner. Whether my learned friend got the opportunity, I don't know. No. I have not received any. We have not received any notice from the deputy commissioner. Well, the direction was direction of the deputy commissioner. Whether deputy commissioner calls the inquiry, I don't know. We don't know. No,
There is a letter from the SDO Sadar Barpita.
who is the SDO Sadar Miller? What directed deputy commissioner? Deputy commissioner, there is a Rajendra Miller that does then police commissioner Maharashtra Miller. Clear. The court directs the deputy commissioner. This is a case of contempt. Deputy commissioner has directed the special officer to do the inquiry, cause the inquiry. Directed the for the purpose of the, both the parties have to be to notice for submitting their case.
This is 2224.
224/8/1 is the order.
Where is the report? These are just communications, subsequent communications.
So this is a procedure picture.
Huh?
So today just.
Right. Heard, Mr.
We are depriving them.
Heard, Mr.
Yes, second.
S. Deka for the petitioners in WPC 2056/2023. Also heard, Mr. S. Pataki, present counsel for the petitioner in WPC 2172/2021. Mr. S. S. Roy appears for the state response. Mr. Narai, this court, right, order dated 8/1/2024. Has directed the Deputy Commissioner Barpeta to cause an inquiry with regard to whether the lands covered by tag numbers 384, 387, 349, 358, 500 and 30 of Revenue Village Kalgachia, Muzarupchi, Barpeta district were wrongly included as a part of the fishery
Within the boundary of the.
That's what I'm saying. I cannot do it exactly as you worded. As a part of the fishery. The said inquiry was to be done by giving an opportunity of hearing to all the stakeholders, whereby they would be in a position to furnish all relevant documents The report was to be thereafter submitted to this board. In a state of. Next. Mr. S.S. Roy, the learned counsel for the state respondent, has submitted two letters dated 2024 issued by the District Commissioner Barpeta and addressed to the Circle Officer Calgachia Revenue Circle. And another letter dated 12/3/2024 issued by the SDO Packet Sadar Barpeta to Mr. K. Gogoi, Additional Senior Governor. With comma which are as follows. Huh? Take this message. We just write one letter dated, so this letter dated. A perusal of the above letters telling those issues that the Deputy Commissioner Barpeta has not acted upon. It has not a perusal of the above letters telling those issues that there is no report made. There is no report of an inquiry made by the authority in person to the letter dated, in person to the order dated 8/1/22. Mr. S.S. Roy can obtain specific instructions by the next day as to whether the Deputy Commissioner Barpeta has caused an inquiry and given an opportunity of hearing to the party prior to taking a decision as to whether the Pataland of the petitioner is included within the notified boundaries of the petition inspection. This is the matter.
5th of April.
Huh?
5th of April.
Okay.
Okay.
Yeah, take it on. Lordship, this is a matter pertaining to non-payment of contractual bill.
Lots of similar things. There
Huh?
is a judge factory is the main party,
That is not
not main part.
what you want to do.
Lordship, I'll file an IA, your lordship, for infringement of the.
Otherwise, the admission is here.
Yes.
Admission is there.
Page number 70.
The page number.
70.
How much? 13,000.
Your lordship, in this matter, your lordship, the total bill amount, is rupees 7,25,361. Out of
Where
that,
are you getting?
your lordship,
Where are you getting that? Which page?
just take your lordship. Your lordship, the representation made by the petitioner.
Then the admission by the. Government. There is no admission.
It is not actually.
There is the admission by the government. When there is no admission, then there is the question of allowing you appraisal.
Yes, sir. Your lordship, may list after a week, your lordship, the other date.
For what?
It is matter, I'm appearing on behalf of Mr. P. Theory, your lordship. Don't take it.
Right. Mr. What is your name?
T.S. Decker.
Yes, Decca appearing for Mr. T. Dury, land counsel for the petitioner. Shall inform the court on the next date as to which document in the writ petition is an admission of the amount claimed. It is an admission of the contractual bills of the petition. This is the matter after 3 weeks.
Yes, Lord.
Where is the admission? None. None, there's no admission. Come on. There has to be an admission. Mr. Rao. There's no question of impediment of parties. You have to show that there's an admission. If there's no admission, you cannot file a writ petition.
Much obliged. Not from the last division, my lord, they have filed their application of going. We need some time, my lord, to respond to the law. Let's be after 2 weeks.
There is a stay order, Mr. Counsel.
The authority which says the subject to them, my lord, part order passed by.
Okay.
I'm praying only 2 weeks.
Mr.
I'm at stake here.
S. Chetia, appearing for the petitioner is granted 2 weeks time to file affidavit in reply. This is the matter.
Deeply. Obliged. Yes, please. It's like a fighting to contextual business around sector.
Contractual, where is the admission?
Admission is page 54, 55. Last 2 pages.
54, 55. Incomplete.
Complete, Lord.
Up to date progress incomplete. Work completion certificate. Page 55, it says incomplete. Up to date progress incomplete.
And down with
Leave the leave completion.
finance. It is completed, Lord. Yes, for my inspection.
But where is the amount claimed?
And amount claim receipt 31 lakh,
Where does it say 31 lakh?
31 lakh, I have mentioned in page number 10, Lord.
No, it's the admission by the
Oh.
authorities. Where's the admission that they are liable to pay you 31 lakh?
Not to the liability statement.
This is only work completion certificate. There's no liability statement.
Bill value, Lordship, I have page 54.
Pay?
Page 54 and
Yes, I've got 54. What does it say? This is work order value, bill value. Nothing about for how much is the balance payable to you. Nothing is there.
I will pay you. Actually, but you what?
Huh?
We technically get.
Mr.
Say that.
Dedas, then counsel for the petitioner. In granted 2 weeks time to obtain instructions as to whether there was any admission by the state respondents in respect of the contractual liability payable to the petitioner. Page 54 and 55, which has been referred to. Page 454, 55 of the writ petition, comma, which has been referred to by the petitioner's counsel, does not show that there has been any admission of any contractual due. This is the matter after 2 weeks.
I will. Allotment Peru's order dated 23/1/2020. Whether the matter was fixed for the government to based on record. The status. No, I have received this. The gazette notification has been published on 22nd of February.
Give it to him, give a copy to him.
Yes, I have, yes.
So what is to be done now?
Lordship may take it on record, Bharat, and we have already issued the notice, just a notification that has been issued. After receipt of suggestion and objection within a stipulated time, final notification will be published, Bharat.
These are draft rules.
It's a
It's
draft.
not the final rule.
Yes, yes, Bharat. The second, Bharat, now Bharat, the notification has been issued, taking for objection and change, not is ready. After that only the final will be.
Yeah, you are notifying a draft rule in the Gazette. Is it done?
Yes,
No, why? How can it be done?
Bharat,
It's a draft rule. You cannot, you are just playing around with
public.
Huh? Huh?
For public outreach. Suggestion and public. I have given the gazette for that.
public consumption. Correct. It's only for public consumption. You just playing around with it.
I have given the public gazette.
Gazette, you see, at the end of the day, whether it is a Gazette notification or not, the fact remains that it is still a draft rule.
Yes.
A draft rule means what? It is not a final rule.
Draft rule, Bharat, yes, it is draft rule, Bharat. And the, kindly take the letter. Just from the letter I'm mentioning, Bharat. The draft notification, the Assam Industrial and Employment Standing Order Amendment Rules 2024.
Where are you reading?
In the letter,
Where does it say? Where does it start? It starts with reference to.
so I have read the second part.
It says that from second part. How does it start? In this regard.
In this regard, it may be mentioned that draft notification on the Assam Industrial and Employment Standing Order Amendment Rules 2024 has been published on 22nd of February 2024. And the Gazette notification of the rules have been issued on 5th of March 2024. After receiving suggestion, objection within a stipulated time, final notification will be prepared and published after the cabinet approval. One. That is what we have already mentioned in our evidence. And the draft has been published. Now, Malak, kindly give us some time.
It is 19.3. Where is the principal secretary? As per the last order.
But processor directed the principal secretary to advise the. I have received the instruction from the operator.
Okay.
On last occasion, the order dated 23.
So the principal secretary was the apprise, not the deputy secretary.
But it is. Yes. The information has been given on this instruction.
Huh?
It is as per the instruction of the principal secretary for a clear report.
When it says principal secretary, it is principal secretary.
But I'll file an affidavit bringing this of that.
What will you file?
See, bringing this draft. Look, kindly see the last affidavit,
Just a minute.
the affidavit of file earlier. On 19/1/24, we have filed an
Just a minute.
affidavit.
This letter is not as per, this letter says that draft notification of the Assam Industrial Sector Employment Standing Order has been published on 22/2/2024.
Yes.
Where is the 22/2/2024?
So that the notification 21st of February 2024.
So 22 and 21 is different,
In the-
Mr. Counselor.
In the Gazette,
In the Gazette, where does it say 22?
notification 21st of February. That's 21st.
Huh?
Notification is 21st of February 2020. Notification, just the order by the governor, labor welfare department, labor department.
We are not worried about, we are just playing around.
But in the affidavit, we have stated that we have taken this step and they are.
Okay, so 5th March will end on 5th April.
Yes.
30 days you are taking.
Not-
Right. Mr. Third Mr. V. Prasad and Mr. Dinath. Mr. Dinath has published the notification dated 21/2/2024, which is the Assam Industrial Employment Bracket Standing Order Bracket Clause Amendment Bracket Clause Rule 2020, which has been notified in the Assam Gazette on 5/3/2020.
They are concerned with the age of radar. That has been proposed.
You see, outside this letter, you said after receiving suggestions and objections,
Yeah.
how many days have you given?
Well, in the first paragraph, just I'm taking first. If the following draft of certain rules order to amend the Assam Industrial Employment Standing Order Rules 1947, hereinafter referred to as the principal rules which the Governor of Assam proposed to make in exercise of the powers conferred by subsection 1 of section 15 of the Industrial Employment Standing Order Act 1946 is hereby published as required under section 15 of the said Act for the information of all persons likely to be affected thereby, and notice is hereby given that the state draft rule shall be taken into consideration on or after the expiry of the period of
After can be till kingdom come also.
but, after 30 days from the date of publication of this notification,
Correct, on or after, where is the outer limit?
but it is 30 days, Lord, to my understanding.
Then your understanding is very wrong. I can understand if it's on or before 30 days. Out here it is on or after 30 days. There's a big difference, Mr. Council. You are a very seasoned advocate. I don't think this will escape your notice. But please do not try to, take it out of the ambit of what is
But
written in.
this possibly has happened because the notification is of 21st of February, but it is published on 5th of March.
Maybe
Therefore-
on or after.
Therefore, Lord,
On or after 30 days of what?
30 days from the date of publication on 5th of, it is on 5th of April. it is- Even if after 21st of,
From the
March.
date of publication of this notification, read the entire thing.
Yes, yes,
Don't read whatever part you like to read.
yes,
only.
Lord, 30
But-
days from the date of publication of this notification in the official.
Yes, official gazette. From the date of publication, not from the date of publication of the notification,
On 5th
but
of,
in the gazette.
5th of March.
I didn't expect this of you. I thought you would be more straightforward.
But-
Please do not try to be so smart.
No, I'm not trying to.
Yes.
I'm not trying. But
Yes. If you're not trying, please read it as it is.
yes, I have. 30 days from the date of
I think we'll
publication.
call your principal secretary to explain whether it is 30 days on or before. Because the way that you try to read something there which is not there. On or after from the publication in the official gazette
After
means
the-
from 30 days to any day, it can be after 10 years also.
It is unlimited.
Unlimited,
It is
infinity.
Look, logical, if you want it, I'll bring it on record and clarify that. Because they have published as per section 15 of the act. Possibly they are something.
Provides that the draft rules shall be taken into consideration on or after the expiry period of 30 days from the date of publication in the official page. Next up.
Logical also see the next paragraph. Here they have said that any objection or suggestion which may be received Body understand from any person with respect to the said draft rule before the expiry of the period specified above
Right.
shall be considered by the
Right.
government of
On considering the notification dated 21/2/2022. It has been published in the official gazette on 5/3/2014, 2020. The learned senior government advocate shall obtain instructions as to the outer limit for considering the draft rule along with any suggestions or objections by the state authority. The same can be published, the same can be submitted by way of an affidavit within,
I mean one.
within 2 weeks. This is the matter on.
So the copy will be on record.
No, it doesn't need it. You don't need it.
I even I will file in the affidavit. Okay.
Okay, relating to lease of a stall by the Dunduma Town Committee that in the district Tinsukia. So, in district, in the record, for some more time, next week, have to go through the record. Just
What to do? You have received the record.
yes.
So what is there in the record?
If I have not gone through the record.
We can all go together to the record. Will it take?
Only in particular,
Right. Mr. S. has got submit that. Praise for a journalist. So that he's able to peruse the report which has been submitted. Official report. This is the matter. After the report.
first week of April,
Okay.
eight or nine,
8 or 9. Yes?
9.
What? Oh, this is over.
Wherein we have taken a preliminary objection regarding maintainability of the petition on two grounds. Firstly, it's not a case where review is maintainable. Secondly, my lord, there is delay of about 700. On this to count, my lord, I filed it. Read the preliminary objection, paragraph 3 of my. If your lordship kindly permits me, I can advance my argument on the maintainability.
This is the affidavit.
Yes, lock that, my lord. It was filed in 2020. 15/6/2020.
No, we can hear all aspects.
If your lordship takes a call on this, I'll satisfy your lordship, my lord, review can't be a re-hearing. Court has already recorded a finding. If that is wrong, then it's a domain of appeal.
And supposing the decision has been made on wrong facts,
Then also it's a domain of appeal. Review can be filed only on limited grounds as enumerated section 114 CPC rated section 47. Otherwise, my lord, 226 confers the power of review, but the spirit of review comes from CPC.
no, but then whether if those facts were not brought to the notice of the court
No, my
to
lord.
pass the order,
No, the question is, if your lordship, can we come to one paragraph of the judgment that will clarify the position? One paragraph in the judgment. Sir. Please come to page 43 of the review petition.
Yes.
Para 42.
Yes.
Reverting back to the case of the Shiksha Sarati, that is the petitioner, we find that notwithstanding their initial engagement for 11 months, their engagements have continued for more than a decade now. As a matter of fact, that the engagement is now in the second decade, which clearly indicates the necessity and utility of Shiksha Sarati as assistance to the teachers. Well, this is a finding of fact. Now, if it is a wrong finding, then it's a domain of appeal. What is there to review this order, my lord? Either this finding is a correct fact or it is not the correct finding. The review can be filed for a correcting if at all there is error in this finding of the honorable court. That's the consistent view of the Supreme Court. But for a moment, we are not questioning that otherwise a review lies or not. A review petition lies, but on a very limited ground. But another most important thing is, if to find out what is the error apparent on the face of the record, it takes my lord a lot of time, then it's unfitting to province of review. And kindly see, my lord, there is a delay of more than 700 days. All right. Or let us, since a review of a 226 petition is under 226, delay may not be, or limitation act may not be applicable. But my lord, if there is lapses, and explanation is what should be forthcoming, that this is the reason which prevented us from, my lord, when the contempt was initiated by this honorable court, then my lord, to overcome that, my lord, this review was filed. Contempt was initiated by division. Then, my lord, this review was filed. Thereafter, because of the pendency of the review petition, my lord, the contempt, though it was initiated, has not proceeded. And I'll satisfy your lordship, my lord, why this review is not applicable. That's my preliminary objection permits, and I can place it. Subject what your lordship. Yes. My first ground is, my lord, there is, please come to my lord, para 3 of my affidavit. Well, I have taken both his stand. Para 3. Para 3. Sir.
is it dated 18 June?
Yes, my lord. Yes. 2020. Para 3 at page 2. That at the very outset, the answering respondents humbly beg to raise a preliminary objection regarding the maintainability of the review petition itself. In this regard, it is humbly submitted that in the guise of a review, there cannot be re-hearing of the factual position already decided. A perusal of the amendments made in the present review petition would go to show that contention sought to be advanced has already been considered by Honorable Bench while rendering the judgment dated so and so. Therefore, in the humble understanding of the answering respondent, review petitioner had miserably failed to make out a prima facie case in his favor so as to enable the Honorable Court to exercise its inherent jurisdiction of review. It is no longer res integra that power of review must be exercised within the framework of Section 114, read with Order 47, Code of Civil Procedure. Further, in view of the catena of the decisions rendered by the Honorable Supreme Court of India, it is not permissible to entertain into the merits of the case while exercising the review jurisdiction. Furthermore, before exercising such power to review, the Honorable Court must arrive at a prima facie satisfaction that there exists an error apparent at the face of the record, and such error should be of such a nature that it is easily identifiable. If a full-scale hearing is required to ascertain the error, then it is in the province of an appeal. Therefore, review petitioners have been failed to make out a prima facie case for review of the judgment and order.
Just a minute.
Yes. Then,
No, one thing is that can you shorten it because
Yes.
because this is the normal thing.
Huh.
Basically, you're basically saying that.
No, yes, second, all right, my lord. My
you
first
cannot
point, I
partake
agree
the
that,
character with the-
okay, then my lord will kindly come to page 4. Very
No,
short.
what we were just discussing, the objections which you are taking, these are maybe valid objections in a review. But if you question the maintainability,
Ah.
it has to be so apparent that there is a legal bar or some bar that the legal.
Yes, I'm coming to that, my lord. Now, please come to page 4. That is the legal part.
Just make it very short.
Very short. My lord, what I have said is, stricto sensu, though Liquidation Act may not apply in case of review, but if there is inordinate delay, at least the review applicant must give some explanation. There is
For 700 days,
670 days.
670 days, no
Yes.
explanation.
There is no explanation.
Okay, that is
So
one.
therefore, my lord, this review petition cannot be, at
And
least
number
on this ground, it cannot be entered.
And number two,
That, number 2, my lord, a review can
cannot,
be hearing.
cannot
Partake
partake
the
the character
character
of
of edit. These are the two.
I think, so let it come.
If we look at the provisions of Order 47 Rule 1, it is very clear. I would like to place all the judgments, but the law is very clear and the language is very clear here too. Order 47, Rule 1. That if there is a discovery of a new fact which was not placed at the time of hearing, I like this. So I am taking where my learned friend has just taken over page 43, paragraph 40. Because in a nutshell, because I don't have to go for a prolonged hearing or a submission or argument to convince this honorable court that there is a ground for review. Unless I am being able to satisfy this honorable court that prima facie on the face of record, Lordship is convinced that a very vital fact was missed out. So paragraph 42, which my learned friend, I was supposed to place it at the last, but I'll let it start from the reverse way now.
How many judgments?
Judgment. Reverting back to the case of Shiksha Mitra, Shiksha Sarathi, we find that reverting back to the case of Shiksha Sarathi, we find that notwithstanding their initial engagement for 11 months, their engagement have continued for more than a decade now. As a matter of fact, their engagement is second decade, which clearly indicates necessity and utility of Shiksha Sarathi as assistant to the teachers. So the Honorable Court come to a conclusion that they have continued for about 2 decades.
More than 10 years.
More than 10 decades, they're in the second. Now, when we wanted to proceed with for implementing the judgment, because the Honorable Court has directed, what the Honorable Court was pleased to direct, page 45, paragraph 44. Therefore, having regard to the grievance expressed by the petitioners and the discussion made above, we are of the view that it would meet the ends of justice if similar benefits as granted to the master roll, work charge and similarly placed employees working since last more than 10 years, not in sanction post, is extended to the Shiksha Sarathi. Accordingly, we direct the state to consider framing a scheme of the Shiksha Sarathis on the above line, which decision shall be taken within a period of 6 weeks from today. So the government was directed to frame a policy. Whether in what way the similar benefit as it was granted to the master roll workers and other similarly situated employees, they were given notice. They were not allowed to leave the job before 6 years. That means their service was extended to 60 years because there was a huge bunch of cases where there was a prayer for regularization of master roll workers and other similarly placed cases because of the various legal parts of the Honorable Supreme Court judgments or it. Even if we were willing, we are not being able to do so. We considered it within the case that will not regularize them, but will give them benefits. Their job security will be there. That till 6 years they will not be removed from service, and they will get some benefits like medical benefits and insurance benefits, certain benefits at the time of retirement, not the pensionary benefit. So that was a concession from the state government that the honorable court very rightly have granted them the same and also the pay scale also.
You have granted them.
Yes, we have granted.
Yeah,
for-
it is-
No, for the
To the
master roll
master roll and
workers,
contract
workers, for various other work department like
So
PWD, irrigation, etc. Same benefits they were asking here.
Oh, this, let us say people. want it.
Exactly, Lord. So this was the direction given by the honorable court. So after this judgment, we started to find out what is the situation, how to frame the policy and how to give the benefit. Then we realized, we found out a very vital material, one judgment of 2005 and one very important document of 2005, which we have placed. This is why the review we have placed. Lordship will kindly come to next page, page 47. These are not new documents, but these documents should have been placed at the time of hearing. 28 December 2005, from the Mission Director P.K. Tiwari to the Joint Secretary, the Government of Assam. Status reports of contractual engagement of para teacher Shiksha Sarakhi 1 in single teacher post, lower primary school. Please find enclosed here with a status report on contractual engagement of para teacher Shiksha Sarakhi in single teacher lower primary school for information of the Honorable Chief Minister Assam, P.K. Tiwari, Mission Director. So that second piece is the report. Status report on contractual engagement of para teacher Shiksha Sarakhi 1 in single teacher lower primary school. Assam Sarva Shiksha Abhijan Mission Assam engaged one para teacher Shiksha Sarakhi 1 in each of 6,001 single teacher lower primary schools of the total of 7,610 lower primary schools reported to be single teacher schools in the state government's policy during the year 2004 and 5. This Shiksha Sarakhi 1 were selected and engaged with the school management committee of the concerned schools on contractual basis for a period of 11 months in accordance with the agreement signed between SMC and Shiksha Sarakhi 1. The 11 months period of agreement expired on 31st August 2005 for most of the Shiksha Sarakhi 1 and will expire shortly in respect of a few. The project approval board, PAB of the Government of India, did not agree to approve our proposal for making the provisions of one para teacher in all 7,610 number of single teacher LP schools in the annual work plan and budget for the year 2005 and 6 on the ground that Assam has a favorable people teachers ratio and failed to rationalize the deployment of teachers. In view of the stance taken by the PAB of the Government of India and lack of budgetary provisions in the so for 2005-2006, it was not possible for the Assam Sarva Shiksha Abhijan Mission to extend or renew the contract period of the para teachers engaged in 6,001 number of single teacher LP schools any further. Their contractual engagement will automatically come to an end on expiry of the present agreement period as per the terms and conditions of the agreement signed by them with the respective school management committees. Some Shiksha Sarakhi have filed cases in the Honorable High Court for extension of their services up to year 2010, till which year the Sarva Shiksha Abhijan Mission is to continue. The Honorable Court by an order dated 17/11/2005 has dismissed the writ petition filed by them, copy encloses annexure A. In view of the facts mentioned above, there is absolutely no ground for entertaining the claim for extension or renewal of the contractual engagement of the persons engaged as Shiksha Sarakhi 1. This is the report and the judgment at page 50. 17/1/2005 Honorable Court Judgment. Heard J. Mullah, so and so, so and so. The petitioner are 55 in number who were appointed as Shiksha Sarakhi for the period of 11 months which has expired. The relief rate in the writ petition is for a direction for consideration of their cases for extension of their services up to the year 2010, till which year the Sarva Shiksha Abhijan Mission is to continue. In support of the relief rate for reliance has been placed by the Learned Council for the petitioner on an order passed by this court in a similar matter which is registered and numbered as WPC so and so. A copy of the order of 38/2005 passed by this court in the aforesaid proceedings has been enclosed in the register. The same has been duly perused. To ascertain as to why Shiksha Sarakhis are being appointed for 11 months and whether the court should pass an order of extension of their services on expiry of their contractual appointment, and as instruction was not forthcoming from the Learned Standing Council, This court has required the mission director to be personally present. He is accordingly present today. After hearing Sri Tiwari, mission director has submitted that Shiksha Sarathis are the second teachers provided to LP schools, which schools by virtue of their students teachers ratio is entitled to have a second teacher. Sri Tiwari has further submitted that scheme for appointment of Shiksha Sarathis and making provisions for a second teacher in the LP school under the state Sarva Shiksha Abhijan mission has been discontinued pursuant to a policy decision of the government of India and a parallel commitment received from the state for appointment of regular second teachers in some such LP schools. The Tiwari has very categorically stated before the court that the scheme for appointment of Shiksha Sarathis having been discontinued, and by and large no Shiksha Sarathis being in service at present, except a few cases where the period of contractual appointment is not yet over. This court finds no apparent justification for following the earlier orders passed by this court in the connecting proceeding. This plea of discrimination advanced by Sri Mullah, learned counsel for the petitioners, does not find acceptance of the court, inasmuch as, in view of the stance now taken by the mission director personally present, the order passed in the proceedings earlier cannot form the basis of continuation of such orders in phase proceedings. In the light of foregoing discussion and for reasons recorded, I find no justification to continue to entertain this petition. The decision according dismissed, no cause. So from 2005 onwards, nobody is working. This vital fact was not placed before the honor. At the time of framing a policy in terms of the full bench judgment, we found out all this. So in that view of the matter, Lordship, this is a review which is maintainable. If we look at the language of review order 47 rule 1, may I read it, Lordship? These two documents are the only grounds which we are forwarding before this honorable seeking a review of the order. If we have to implement that policy, all the master roll workers, which are about 25,000, they were all working all across. There was no disengagement or break in service. Here we have to invite all these 6,000 plus another batch of about 600. Again, after 15 years to allow them to take the salary, which is not the idea of this honorable court also. So what is the language of order 47 rule 1? Application for review of judgment. If any person considering himself aggrieved by a decree, etc., now I am coming to C. By a decision of the reference from the discovery of new and important matter or evidence, which after exercise of due diligence was not within his knowledge or could not be produced by him at the time when the decree was passed or made, or on account of some mistake or error apparent on the face of record, or any other sufficient reason, desires to obtain a review of the decree passed or order made against him, may apply for a review of judgment of the court which passed the decree or made the order. So we fall into two categories. There is a mistake on our part. We fail to produce this very vital information to the court, and also on discovery of this new fact on two grounds, which is permissible under the provisions of CPC. We are before this honorable.
Only there is one thing. Which is this order of the single judge has been passed in 2005 November.
Lordship.
And the division, the full court has passed this order on 2017.
Yes,
So how do you, because,
justify.
yes, that
That is
period,
where I am saying that it is a mistake on our part. If a mistake is on the part of the advocate, I'll face some judgment which permits it. This can be a ground for review. Because it may be deliberate, it may not be deliberate. Why Mr. Tiwari was called to the court in 2005? There was no information coming from the standing council of that department at that point of time. In 2017 also, we do not know. There may be some deliberate attempt to place the complete facts before the honorable court. We do not know. We'll find out why it was not placed.
Mr. Advocate General, Lordship, even if we for a moment ignore the judgment of 17/11/2005, that may not come to your knowledge somehow.
Yes.
But the director has come to the court to deliberate on an issue
which is exactly the issue which was for the full bench.
Yes.
That was within the knowledge of the director.
Director had changed.
This, we are on the director, we are not
Yes,
the
yes,
PRD or
I-
anybody.
yes.
It was in the office, knowledge of the office. This is the matter before the full bench, which was decided in 2017. Issue is exactly the same. That should have been the first point of
Your
defense.
Lordship, what was our submission? I'll just place one paragraph from the judgment. We
Because
have,
what you are contending appears to be something very substantial.
Very
That you have not continued.
Yes.
But if that is not the defense taken, after 2 years, when it was the very much the defense available, and should have been
I
taken.
fully agree, Lordship. With all my humility, I am seeking apology from this honorable court that this vital fact was not placed. Therefore, Lordship, I would like to place what was our submission. Because on identical case, identical facts, Shiksha Mitra, another division bench, dismissed the plea of the Shiksha Mitra. That was highlighted, and also
I think that was discussed. in
that
the
was
full bench.
discussed, that was discussed. Paragraph 15, page 27. Paragraph 15. On Lordship. On the other hand, learned standing counsel SSA has raised twofold objections to the prayer made by the petitioner. The first objection relates to res judicata, in respect of which he submitted the earlier division bench decision in Orup Kumar Bhuya Supra has finally decided that the issue raised by the petitioners and the same cannot be reopened again. So same fact. So division bench dismissed their case. Secondly, on the issue of regularization, he submits that the appointment of the petitioners were contextual in nature for 11 months, which they have accepted. Therefore, petitioners cannot seek regularization of their service. In this context, the following judgments were placed. So in the affidavit filed by SSA, very clear that the service was for 11 months. I have gone through the affidavit, which is a part of the record.
Affidavit, before
Before the learned, it was filed.
the.
Yes, WPG 5002 of 2012.
So there would be a difference that the contractual period may be for 11 months. What you are now contending that they did not even continue.
They did not continue.
Now here what was stated that the period was for 11 months. Whether they continued or not, there was no affirmative statement or submission. That 11 months over, they were not allowed to continue.
They are not paid also. Because the government did not, because this is a central government sponsored scheme. The whole fund, it is totally central government sponsored fund. So that is why when the PAB, the Project Appraisal Board for 2005-6 said that we are not going to give this money. Therefore, you cannot engage these people any further. So money was stopped. Therefore, the contract period was not extended. And there is no point of state government giving some money here. And on top of that, in 2009, when the RTE came, these provisions are all become redundant. All the school must have the appropriate number of teachers to fulfill, as per the NCT.
You see, when you are referring to this PAB, what you call observations.
Not.
In one of those observations, the PAB says that the liability to pay salary is so the liability of these teachers are with the state government. It's a specific
Yes.
statement made here.
These are not teachers. These are not teachers. They are assistant to the teachers. Thoroughly. These are not teachers totally. That is where the Sarva Shiksha Abhiyan comes into play. They fulfill all the deficiencies wherever it is required. It is a Sarva Shiksha Abhiyan is also a central government scheme under a society. Now, what I am trying to emphasize before this, suppose we want to implement it. So we have to find out these 601 who are no more in service from 2600. We have to invite them again. There are two batches. One batch consists of 6,100 and the second batch consists of 463. We have done the whole exercise now. And nowhere we have found anybody is working. That in our additional affidavit, affidavit filed in the review by Vijay Chaudhary, page 55 onward. Page 55. where we have explained the delay also. So there's a direction, but let me first place the facts. I'll come to the delay a little bit later on.
It cannot be 55. 55 is there.
It's the,
Affidavit of position.
if it, if it filed by the review petitioner to explain the delay,
No, cannot be 55. No, it's 55. It's 55. It's affidavit of Federal Board. It's Kiran Borough.
in any case, Lordship may kindly take the affidavit filed by the review petitioners to explain the delay in filing the review by Vijay Chaudhary, Dr. Vijay Chaudhary.
So there is another. Towards the last first.
It was filed sometime in
Yes,
the
yes, we have seen it.
Vijay
third
Third
of
of
November 2022.
Same patient.
This is first step. The 254, 255.
In my pair phrase also it is 54. It starts from 54.
Before that, I just want that letter you talked about, letter dated 28, which page is that? 47.
28/12. Yes, that is there. Page 47.
Where is this order passed in this 3743 of 2011? The single judge's order. And W8 222 of
Mr.
2011.
Goyari, Lordship.
Yes.
3743.
Does he mention anything about the contractual period of the with the SSA having expired? Is
I
it
just have a cursory look. Lordship. I have the judgment. One of the finding of the court, may I read it, Lordship?
Yes.
In the backdrop of the above facts, let me set out in substance as to what the case of the writ petitioners is and what relief they have sought for in the light of the objections raised by the state respondent and the provisions of law relevant thereto, whether the petitioners are entitled to the relief, if any. The case of the petitioner in a nutshell is the petitioners herein were, upon selection by village education committee, engaged as Shiksha Mitras, educational volunteers, pursuant to the education guarantee scheme. Each of the writ petitioners were engaged as Shiksha Mitras and entered in this regard into an agreement with the VEC, which provided inter alia that contract agreement appointing the petitioners as Shiksha Mitras would stand terminated on completion of a period of 11 months unless renewed. Also that any service rendered under the agreement should not under any circumstances whatsoever would give the Shiksha Mitra the right to claim in regular absorption in the regular vacancies that existed then or to be arisen in future in the state or in any other educational institution. The Shiksha Mitras being, however, entitled to an honorarium of 1,000 per month.
Just a minute, Mr. 81. Just get us the order, WPC 3743 of 2011. How many pages is it?
It is
Short.
very long judgment, very elaborate. 11, it is total. It will be 11 pages.
Just give it. 3743 2011
Very long judgment.
and
Every aspect has been discussed.
and WA 222 of 2012.
The other one, Lordship, it is an next.
It is an extra.
It is an,
Where is that?
oh. In one repetition, it has been engaged. Yes, WA 222, it is in page 295 in WPC 5002 of 12.
That is not here.
That maybe I have a copy.
How many pages is it?
This is also, this is not very long.
Then we'll have
The number of petitioners are too many. That is, otherwise it is only 2 page judgment.
Okay. Triple two without the parties, without the party. Then we have 3 copies. WA 222 is not uploaded. Okay, can we have it photocopied? Let's have it photocopied. 3 copies. Huh? Tell him without the parties. No, that's WA. Just tell him without the parties.
Judgment because. Where? So there were basically 2 issues. One is regularization, other one is they want the benefits of the master role workers. The regulation till now they have not been able to get from any of the honorable courts. Only thing regarding the benefits which were given to master role, this was the same benefit. Only difference between the master role workers and the other group of employees is that they had continuation of their services. Here, there is a huge gap. That is the distinguishing factor. Otherwise, it would not have been any problem for us.
You see, the problem is basically with the issue of the para 42.
Para 40.
Para 42. Now, when they have made a categorical finding or observation, what was the basis for it? or that is one that can be seen. Or on the other hand, did you ever take this plea that they have been there for on contract basis for only 1 year in any of the proceedings?
That was the only stand. That was the only affidavit I could go through. And in this case also, Buddheswar Goyari case also, the learned single judge said that there was a specific order. There's a reference just I have gone through. By they were the easiest scheme, the education guarantee scheme, those centers were upgraded to LPs. So at that point of time, it is necessary to have teachers. So they were all these young kids. So they came before the honorable court in Goyari's case. So in that view of the matter also, nobody continued beyond 2009. So when the judgment was passed in 2017, there was a gap of 8 years. They were not in service.
The issue is 42 bit. Have to
42, yes, but 42 is prima facie. I don't have to argue that it is not based on correct facts.
But you did not take it up.
We did not, that's why we are before this order. We are saying that we have committed a mistake. For our mistake, that 8 years gap of 20.
Did you take this up in that writ appeal? This at that
That,
time.
that was not the, only
That was
two
not-
points, only 2 points were argued. One is that it is a case of res judicata because identically placed batch had already approached and their case was facing dismissal in the appeal. And other one is also that it is not, they cannot be granted regularization. These are the two grounds.
Let us see the order.
Only because of the master roll workers came up in between Upen Das case. They have prayed, they have molded their prayer. That prayer was never there in the writ petition or in the appeal also. It was more or less a consensual on order. Okay, correct. It is.
Before the
And very elaborate report is there in our affidavit in opposition to the delay. Very elaborate. Page 65.
in this 5002, this was submitted in 2015. So you have said that they were on contract basis for 11 months. You have not stated that they have stopped working.
So that does not also imply that they are working for 20 years or
Correct,
more than
correct.
1 decade.
It does not.
Yes. Now Lordship will kindly take one more page. If Lordship is pleased to take page 63
Of?
of the affidavit in opposition of that affidavit filed in review application for the explaining the delay. When we have done the exercise afresh now, we got some more document and we have also done a press inquiry on whether anybody was working. Page 63. This dated, letter dated 21/11/2018. Aruna Rajoria, Mission Director, Sarva Shiksha, representing to the Elementary Education Commissioner and Secretary.
Affidavit of position
Affidavit in opposition, Lord.
filed by,
Affidavit, not opposition, affidavit filed by the review petitioners to explain the delay in filing the review.
Joy Chowdhury,
Vijaya Chaudhary,
page 63.
page 63, annexure C.
Yes.
So if Lordship come to page 61, we received the certified copy on 3rd of November 2017, page 61. Sorry, here. With reference, I am directed to send here a letter received from the President Secretary of Kamrup District Shiksha Sarathi 1 Teachers Association, along with a copy of the Honorable High Court order dated 26/10. So the Deputy Director Elementary wrote to the Mission Director. Next page, Deputy Secretary of Government of Assam wrote to the Mission Director. With reference to the subject, I am directed to forward a copy of the petition dated nil along with a copy of the Honorable High Court's order dated 26/10 received from Surya Kumar Boru, President. You are therefore requested to kindly examine the matter in the light of the directions passed by the Honorable High Court by taking into consideration the background of their engagement and to submit specific views within 10 days to this department for further examination and disposing of the matter within the stipulated time. This was on 22nd November. So immediately we are taking action. Next page, the report forth from the Mission Director, it is here. 21/11/2018. Information on Shiksha Sarathi 1 and Shiksha Sarathi 2. Letter dated 5/11/2011. With reference to the subject cited above and later under reference, I would like to submit herewith the list of Shiksha Sarathis 1 and Shiksha Sarathis 2 as submitted by respective district mission offices on the basis of available record. I am enclosing a note on Shiksha Sarathi of former Mission Director P.K. Tiwari, which may be useful for the court case. This is for your information. Note on Shiksha Sarathi, summary sheet of district-wise report, district-wise list of Shiksha Sarathi and Shiksha Sarathi 1 and 2. Next page, Lordship, I have already placed this in the earlier. Sorry, this is the letter of P.K. Tiwari to the Honorable Minister Education. Shiksha Sarathi 2, where para teachers engaged on contractual basis at selected upper primary and upper secondary schools where from single teachers in mathematics, science, English, and Hindi got selected through the open selection test conducted in the district for engagement as cluster resource center coordinator, additional block resource center coordinator, and resource teachers under SSA. The process of engagement of SS2 was started from 2003. It may be pertinent to mention that as one of the requisite qualification for cluster CRCC, additional block resource ABRCC and resource teacher is teaching experience in schools for definite period of years. It had necessitated to utilize the services of working teachers in the SSA intervention. In the selection and engagement process, the selection committee of the concerned school selected the SS2 of their schools as per guideline. The school management committee of the school, after the selection, execute an agreement with the SS2 for their contractual engagement. Though a total of 545 number of schools were approved by the State Mission Office SSA for engaging SS2, yet only 463 SS2 could be engaged by the different school management committees. The engagement of SS2 was initiated on the basis of the Cabinet Memorandum. The SS2 thus engaged were to be released from their school with effect from 1/6/2006 on compulsion of for not having budget provisions for APWNP 2006-7 of SSA Assam.
Mention may be made that the project approval board of the government of India strongly objected to deployment of any para teachers in schools of Assam on the plea that the pupil teachers ratio in Assam is favorable than the national standard. The PAB has also insisted upon the issue of double salary payment, which obviously will arise as the teachers who has been taken on deputation to SSA and also the person SS2 who will be engaged will have to be paid from the SSA budget. Consequent upon the release of SS2, the head of the institution lost the services of SS2, which were working as substitute, though on lump sum remuneration of teachers deputed to SSA. It may thus so happen that the release of SS2 will compel the school authorities to call back their original teachers working as APRCC, CRCC, and RT in the interest of the students of the school. Under these circumstances, SSA will have to lose abruptly the services of the resource persons, CRCC, RT, and APRCC, whose capacities were built through different training programs held from time to time. For your kind consideration, the then mission director wrote to the education minister. Now the report. Abstract of release of SS1 and SS2 and number of APRCC academics and CRCC in 9 DPEP districts. Release of SS1, that's 6 out of 6,975 number of approved single teachers LP schools in all districts except NC Hills and Sibsagar, a total of 6,001 SS1 were engaged in single teacher LP schools during 2004-5. The selection / approval of engagement, etc. of SS1 had to be completed by 18 September 2004. But it was found that in some districts, the selection approval process of SS1 could not be completed by 18 September 2004 due to some disputes, legal suits, etc. Thus, the process of selection, approval, and training, etc. continued in the district. As per the report received from districts, the earliest date for completion of 11 months term of engagement of some SS1 were 31st August 2005 and the latest being December 5, 2005, depending upon the date of their engagement. Accordingly, a letter was issued to the districts on 29 August 2005, asking not to renew the term of agreement again and let the present term of agreement automatically come to an end on expiry of the period of present agreement. Why SS1 were released? In view of the stand taken by the PAB of the Government of India and absence of budget provisions for providing para teachers in the single teacher LP school in the APWNP 2005-6, it was not possible for SSA to extend or renew the contract period of the para teachers engaged in the 6,001 number of single teacher LP schools. Their contractual engagement automatically came to an end on expiry of the present contract period as per the terms and conditions of the agreement signed by them with the respective school management committees. Release of SS2. Out of 546 number of approved schools, only 463 number of SS2 were engaged on contractual basis as selected upper primary and secondary schools were from single subject teachers in mathematics, science, English, and Hindi got selected for engagement in SCRCC, ABRCC, and RT under SSA. The process of engagement of SS2 was started from 2003. Why SS2 were released? The SS2 were released from their school with effect from 1/6/2006 for not having budget provisions in the APRW 2006-7. Mention may be made that PAB of the Government of India strongly objected of deployment of any para teacher in school of Assam as the PTR in Assam is more favorable than the national standard. The PAB has also insisted upon the issue of double salary payment, which arises as the teachers who has been taken on deputation to SSA and also person SS2 engaged against the cause vacancy, both have to be paid from the SSA budget. Accordingly, a letter was issued to all districts except Karbi Anglong and NC Hills, where no SS2 were engaged on 17/5/2006 to release all the SS2 with effect from 1/6/2006 and engaged in their district. Number of ABRC academics, etc. ABRC 56, TRCC 150-100. How remuneration was paid? Shiksha Mitra for ECS Center ₹1,000, Shiksha Karmi Alternative School 1,000, SS1 single teacher 1,500, SS2 against cost 1,800, 2,000, and 2,500.
Next page. Engagement of SS1. A total of 6,001 number of SS1 were engaged in single teacher school LP school during 2004-5 in all districts except NC Hills, Karbi Anglong, and Shivsagar for 11 months against agreement made between SS1 and the school management committee of concerned school. In 2005-6, there was no provisions for extending the term of agreement or engaging SS1 in the PAP approval meeting of AP, AWC and B.
Can you have got the pleadings in 3743?
I think I have just found one.
The writ petition is 3743.
These
3743 of 2011.
we'll find it out, Lordship. No difficult.
Can you bring that? Is it 502 or 500? 5002 pleading writ petition will be here.
5002 we have.
You've got, let us see the writ petition. What does the petitioner say?
They were saying that school headmaster.
500. That'll be, 500. That's here. Okay, that is here. Second. That is the one, no? Let us see the. Let us see. Continuing service.
May I just ask, under the new education law which is in force, along with read with NCT, what is the minimum qualification for a teacher?
Qualification. We have to follow the NCT guidelines. So in most of them, it is for elementary school, it is graduation with DLET. And for the upper school, it is graduation with BA. Plus the TET qualification, that qualification. Here in their petition, in one paragraph, they have stated the petitioners speak to stated Shiksha Authority is one who were appointed in the year 2003 under the Sarva Shiksha Abhijan within the district of Kamrup, having long pending grievances of non-receipt of remuneration, as well as against the action of the respondents to replace them by new sets of requests after expecting services from them for 7/8 years. So they were not getting any salary from 1st June 2006. Our report. I have yet to go to that level. 500. So by their own admission, they were not there from 2009.
That's for their own admission.
Own admission.
Where is that again?
May I give? Is repetition, amended repetition of 2015. 2012.
Where is it?
It's 3 they were engaged. Nine of it.
No, no, okay, this is the one.
If we go by their word, that means 2009, that was the end.
But para 7C, para 7C, they have said that even though the scheme is continuing for the last more than 10 years.
No, these are their statement. Our scheme was not complete. It is not continuing. I have placed all the records. The central government may be called for also. Their facts be clear here. Central government is not made a party, but they would have placed before this honorable court that from
Let us
2005,
see, let us see your affidavit.
our affidavit only one affidavit. That is the actual mistake we have done. Our affidavit lordship will find at page 291. 291 of W writ petition 5002.
There is no 291. This 291.
Serial number, it will be 291.
By Jitendranath Pratap.
Jitendranath Patel.
Like,
Their paragraph 4 and their only prayer was for regularization. Paragraph 4. The deponent begs to state that the present writ petition is not maintainable as it contains disputed question of facts of civil nature. That apart, the writ petitioner has prayed for formulation of a scheme for absorption, and the SSA is not the competent authority to do so. The SSA Assam is a society registered under the Societies Act to implement central government schemes. That's what I was submitting, Lord. And as such, it is not a regular establishment, and the staff appointed under SSA are on contractual basis or on deputation basis. The petitioners were appointed on contractual basis for 11 months, and they, knowing fully well, have agreed to the terms and such contract.
No problem. No. Where is this? I'm not getting it. Huh? No, it's- Actually, there's no flag out here, but
Yes. What was their prayer, Lord? May I just read their prayer down here? They were praying for a student.
Just a moment, Lordship, Shailesh, let me-
Their prayer was to, for a defense of a mandamus, to formulate a scheme, as in the case of Shiksha Karmis in Assam, as well as similar employees in state of Karnataka, Tamil Nadu, West Bengal, Pura, Arunachal, for ensuring that Shiksha service for absorption in regular. This is their prayer.
In 5002.
500, page 197. That is their prayer. And our affidavit 292, paragraph 4. Third line from below, page 292. The petitioners were appointed on contractual basis for 11 months, and they, knowing fully well, have agreed to the terms of such contract, and as such, they are debarred from making such prayer for regularization of their service. There is an arbitration clause attached to the agreement, and they, if at all agreed, can apply for arbitration. This is our step. They are not seeking salary also here. They are not getting anything from June 2006.
What about your say something about RTO of 2009? That the entire,
Yes, RTA has completely changed the whole structure of the elementary school system. There is no such post as Shiksha Sarathi in any school. This is central legislation. So these were when there was less number of teachers or single teachers, the central government formulated that scheme of having Shiksha Sarathis all across the country, not only for Assam. And they did not want to continue from 2005 onward because in Assam, PP teachers ratio was quite favorable in comparison to the other parts of the country. In some states, maybe the central government allowed for few more years, but after 2009, it is not possible. Everything is covered by the RTE Act.
So what we are wondering is the judgment which, for which you have come for review, 42, is of 2017.
Exactly.
RT is of 2009.
Nine. All these
And-
things were not argued or not, it was not there also. Why I am saying this? Because they are then that they are still continuing as Shiksha Sarathi. After 2009, it is not possible. Where we made the mistake, we failed to point out before the Honorable Court that they have left their job in 2006-11. 31st March 2006 was the last day of working. From 3rd June 2006, they are no more in service as Shiksha Sarathi, either one or two. And the main prayer, what they prayed for, that was not granted by the Honorable Court, whether before the learned single judge or before the learned division bench. Only because there was a concession in some masteral workers, they wanted to take advantage of that situation and place it before the Honorable Court. And we failed to say before the Honorable Court that their case with the masteral workers cannot be equated because masteral workers or the workers, they have continuous service from 1993 or prior to that. Their case is not identical. Now, even if we have to apply, now what is the situation? Suppose, Lordship, our review application failed. Is it workable direction for us? We have to call 601 plus 453 Shiksha Mitras who are not there in service from 2006 onward, we have to invite them and have to give them all these benefits after a gap of 15 years, or maybe now it is going to be about 18 years. That is not the intention of the honorable court also.
Just one issue, Mr. Chaudhary.
Fine.
You see, para 42
Yes,
basically says that reverting back to the case of Shiksha Sarathi,
my lord.
we find that notwithstanding their initial engagement for 11 months, their engagements have continued for more than a decade now, as a matter of fact. Now, what is the basis for coming to this?
My lord, the basis for this is our statement in the resolution, which has not been denied. Please come to paragraph. Page number 15, my lord. Para 10.
In 5002.
Yes.
Para 10 of 10.
Para 10 at page 15.
Page 13 project.
So, my lord, there is an amended petition. Yes.
Okay.
That the appellants beg to state that thereafter advertisement was made in the newspaper for filling up the post of Shiksha Sarathi on terms and conditions set forth above. Petitioners had duly applied for the post of Shiksha Sarathi, and on being found eligible, they were selected by the selection committee. They have been appointed on merit basis against one teacher who led Shiksha Sarathi, for which they had to sign a contract agreement with the school managing committee for engagement for a period of 11 months. However, although the agreements were signed on 13/9/2004, virtually their engagement continued up to 2010, and even on that, petitioners are.
And even as on this.
Yes. Now, my lord will kindly.
Now,
come to our-
was there any reply to this?
No.
And,
No reply. Last, my lord, if your lordship just kindly take our affidavit in opposition.
Okay, in the earlier, this is the amended writ petition. In the unamended writ petition, is there something
Yeah,
to this effect?
this petition was very much there. Only 7 A, B, C, those were added. This petition is there in the original petition also.
As I said, para 10 was there, the original
Only
petition.
7 A, B, C.
So
D,
let
those-
us go to the original writ petition. First page. First page.
Only thing is, my lord, I am handicapped slightly.
Okay.
That original-
Unfortunately, we can't give you a second copy.
So you can have this because I have.
No, no,
seen-
it's okay, man.
No, in fact,
No, no, Once a
No,
lot.
no, no, it's okay.
in fact, I have. One,
Okay, let us see the affidavit in opposition filed by the state respondent to that para 10. Okay, anyway, we'll just look at the para 10. What is the reply made to it?
Mr. Chaudhary, the sequence is that the unamended is first,
Yes,
amended petition is the last,
yes.
last. Amended petition is the last.
There is no specific reply.
Yes, that earlier it was there, page 13, para 10. And my lord, in this proceeding, we have filed a photo. That we worked up to 2010, there is no dispute, my lord. There are agreements which are pending.
Acha,
Yes, yes. In the affidavit, my lord.
in the writ petition.
No, in the review. Please come to the affidavit at page number, my lord.
This review.
Yes. Please come to page 32.
page 32 of your affidavit.
affidavit. The contract of this agreement was the bottom shall stand automatically terminated on 31st of March 2010. Page number 30. My lord, my humble submission is, maybe my lord, state has a case, but that would appropriately fall in the realm of appeal. My lord, review cannot be a panacea for every wrong, my lord. Now, my lord, in one judgment of the Honorable Supreme Court, that is 2013 8 SCC 320, para 17, 18, and 20, where Honorable Supreme Court has said, my lord, in which situation a review would lie and which situation review would not lie.
This is the citation.
My lord, 2013
It is
8 SCC 320, Kamlesh Verma versus Mayawati. Everywhere, my
This
lord,
has been, I think, extensively quoted in the latest judgment by Justice Kohli.
Yes.
Kamlesh Verma, yes. Where review is to be exercised, powers of review and not to be.
where not to be.
Mr. Chaudhary, one thing,
Yes.
page 31 and 32 of your affidavit,
Yes,
this agreement is between community volunteer and the SMC. What is
yes, SLC state, school management
management.
committee.
And it is agreement, community volunteer is the SSA person, that SA
Yes.
person.
School management committee is the under my
No,
lord,
no, school
RTE Act.
management committee is okay.
Under the
But the
RTE
other-
Act, my lord, entire administration based with the school management committee.
No, in prior page, you will find that this agreement is between Sarva Shiksha.
Yes.
Page 29 is,
Yes,
this is between the party and the Assam Shiksha.
Ah.
Therefore, Assam Shiksha was paying. In the next page, which we are showing at page 30,
the agreement
31.
between school managing committee and Assam Sarva Shiksha Mission. My lord, we have annexed all those and the agreement which were entered into with some of the members of the association. My lord, here is a case. This honorable court, instead of granting the prayer of regularization, thought it proper to extend the relief what was granted in Upendra 6. And that's the only thing. What is the
Anyway,
benefit?
that is not an issue we
Ah,
will go
anyway.
through. That is
No,
not.
my lord, my humble submission is, this by any reckoning, my lord.
Let
cannot-
me finish my
Okay,
side,
okay,
Lord.
okay.
Then let the other side come, because I have to place complete fact and I have to cite certain very important
Yes,
judgments
yes.
which will clearly support the case of the review petition. If we look at their reply to my delay condonation petition, they have annexed certain documents. Paragraph 6 of their reply. But I have not completed the other part, which I was reading. Let me go serially so that it will be convenient for the honorable court also.
No, but one thing we have got to keep in mind,
Lord.
this is a review.
Yes,
It has
that
to
is
be, it has to be very apparent.
absolutely. And review also, now what they are saying with their document, I don't have to give counter to them. They themselves say, from 2006, I am doing the service on honorary basis.
Honorary.
Honorary basis. So these documents, why should I go and dispute? These documents, they did not tell it at the round of hearing when it was decided in 2017. When we have come with the complete report, now their response is that these are the certificates issued by the school headmasters that they are not working from 2006 or they are working for better, for welfare of the students. They are giving their service on honorary basis. This is their step. So whatever I am saying on the basis of record, it has been fortified now from their documents. So 2006 onwards, if a government servant is not getting any salary or any remuneration, whether he can be considered as an employee or as an engaged person of Sarva Shiksha Abhijan.
Where is that?
first, let us take their heading, paragraph 6. Affidavit in opposition. By, it was signed by one Sri Kiralal Boro.
In the review.
In the review. It was filed in.
Kiral Boro, 18 June.
Yes. 18. Paragraph 6. In this regard, it is humbly brought to the notice of the Honorable Court that the relevant attendance register as well as the certificate issued from the head of the institution would clearly demonstrate that the respondent petitioners continued in their engagement as Shiksha Sarathi 1 for more than 10 years. As such, the statement of the review petitioner and the respondents were released from service in the year 2000, nothing but bad as all assertion to mislead the Honorable Court. Now let us go to their certificates. Page 13 onwards. 2-3 certificates I'd like to read. This is to certify that Nipun Medhi, father on so and so. He worked as assistant teacher without pay in this school from 13th May 2004 to 15th March 2014 as per the proposal of the general meeting of the school management committee. So from 2004 to 2014, he was not getting any salary. He served as Shiksha Sarathi 1 in the school where there was only one teacher under the government approved program of Sarva Shiksha Abhijan Mission for the period 2003-4 to 2005-6. From 2006-7 to 2010, he served as a teacher in each of the 11 months appointment phase in the above period. I wish him bright future. So from a Shiksha Sarathi, he became a teacher. What is this, Lord? This is his certificate. Next. This is to certify that Surya page 15. Work as Shiksha Karmi. Now here another term, Shiksha Karmi. In the New Horizon scheme of SSA under different school development schemes of SSA in Mohpur Primary School from July 2003 to February 2004. And his involvement as trained Shiksha Sarathi in this Mohpur Primary School has been authenticated from different sources. So the school headmaster who is issuing the certificate, he is also relying upon some sources. After that, in the year 2006-7, he rendered his service as Shiksha Karmi, another term, for 11 months in this school. Besides this, it is true that he served as volunteer teacher from 2007 to 2014 in Mohpur. So what is volunteer teacher now? There is way to place a case before the Honorable Court also.
Huh?
There is way to place a court. I'm talking about this person. That if he is a Shiksha Sarathi, let him come as a Shiksha Sarathi. If he is a Shiksha Karmi, he is a Shiksha Karmi. If he is a teacher, let him come as a teacher. Here he has mixed up everything and included a volunteer teacher. 4 different categories. That is not what was pleaded before the Honorable Division Bench in 2017. May I go further now? Next page 17. This is to certify that Kiralal Boro, son of so-and-so. It was impossible to impart education as lone teacher in the Lokopriya Primary School. The executive meeting of the school management committee on 17th April 2002 in its proposal allowed Kiralal Boro to serve as honorary teacher in the school, another category now, honorary. Later on from 2003, he was engaged as Shiksha Sarathi 1 and community volunteer under the scheme implemented by Sarva Shiksha Abhijan Mission. He served in the above post till 31st March 2010 in the one teacher school. Moreover, it is true that Sri Boro did his job as an assistant teacher in the Lokopriya Primary School till 2014. What more is required, Lordship, now? Next, page 19. Mohat Chandra Rabha, second paragraph I am reading. As Shiksha Sarathi 1 under Sarva Shiksha Abhijan Mission in the scheme of one teacher school at Puijala Tengathal LP School from 2003 to 2010 as per the approval of the general meeting of the school management committee. Again, he was engaged as community volunteer in the school in the same school when it is not referred. It is to be mentioned that on March 2010, after the conclusion of the term of community volunteer, Sri Mohot Chandra Bora has been rendering his service in the school till date without pay for the future of the children of the school. So whether this kind of MTS method can be equated with the masteral workers, work charge workers, with whom the government also wants to do it, to regularize them, but because there is a bar created by the Honorable Supreme Court's various pronouncements, ML Kesari and Mahadevi and series of judgment, we cannot regularize them. Therefore, we come with a formula which was appreciated by the division bench. It was not that the Honorable Court directed. We consider that let us do something, at least because they are at the pay end of
That issue we cannot go into.
no,
I
that,
but I
no, that
understand your point.
benefit has been given to them. That
Yes.
benefit.
I know, which
Why we have considered them?
according to you, it should not have been given because it opened us, it was a concession given by the state to master roll employees. And accordingly, the full bench could not have given a direction
Because
for making a scheme on the basis of a concession given to you.
no,
for
I am
master
not on that also, Lord. I am on a different. Suppose these persons also, we wanted to give.
Ah.
Our whole effort was to give them.
roll. But they were
We
not,
found that there is a gap of 15 years not in service. Not in service. We have to give advertisement in the newspaper now to bring this 6001 SS1 and 453 SS2 now. Whoever Lordship, this Honorable Court wanted to give benefits, they are not here. You persons are pursuing this case. It should not have been when it is a service matter, Lord. Normally, the individual person should come. I'm not on merit now, but that is the case. And now see, Lordship, 4 different categories of service they have provided. Volunteer teacher, honorary teachers, Shiksha Karmi, Shiksha Sarathi. So there is a mixture of various roles they have played. And who have engaged them and who is issuing the certificate? The school headmaster. Lordship knows how many persons went behind the bar in our education system. How many enquiries this Honorable Court directed? How many directors and senior officials were languishing in jail till date? Our intention was to implement it. And therefore, we conducted an inquiry and further inquiry said, because the inquiry report which I was placing, it was relating to 9 districts. We did the exercise, we tried to find out what is the position in the district of Kamrup. Not a single person is working in that capacity. It's a part of record. I have not completed my review petition. When we can give it to 25,000 master roll
Just a
workers,
minute. Then, but how much more minutes will you take?
let us do it on some other day, Lordship. I'll formulate everything in a very systematic way. I'll place what are the grounds, the judgment, and then finish it in 1 hour. But if I
No,
can,
no,
I can continue.
we will hear you. There's not a problem.
I want to systematize because the whole thing, too many facts are there because Lordship wanted to go through some old petitions also, the affidavits also. So I can find out everything.
No,
But
no,
otherwise, the main case is very clear that this judgment is not implementable as on date.
that we cannot go into.
Therefore, the only option, we have to put the judgment in cold storage and not do anything. We cannot do that. We have to honor this honorable court directions. So when we wanted to implement it, these are the stumbling blocks we are facing.
Now, the only thing, at least tentatively what we find as on date,
Not-
is that one is the One is the delay, which it,
Delay also, I have
no, no,
explained.
just a minute, which you have explained. Now, the other aspect is with regard to para 42.
Para
Now,
42
para 42.
Yes.
The issue is whether the para 42 was made on the on some basis by the.
Yes, that is why
by
I
the-
have to find the affidavits and whatever statements they have made in their other petitions also. And while whatever was recorded in Milo Justice answering judgment also. So I have to formulate everything. It will be convenient for the honorable court. Otherwise, I can keep on placing the facts. And law is very clear. The one judgment of that is BCCI versus Netaji Cricket Club, 2005 Code SCC. Page 4711, paragraph, just I would like, I just few very important judgments. Paragraph 79 onwards. Yes, paragraph 90, one single paragraph of BCCI. Yes, paragraph 90. But I will place other better judgments also. These judgments clear, squarely covers. My
Para
fault
90,
is that the
Para-
fault on the part of the advocate here.
para 90.
Para 90. Thus, a mistake on the part of the court, which would include a mistake in the nature of the undertaking, that may also call for a review of the order. An application for review would also be maintainable if there exist sufficient reasons therefore. What would constitute sufficient reason would depend upon the facts and circumstances of the case. The word sufficient reason in Order 47 Rule 1 of the Code are wide enough to include misconception of fact, that is applicable here, or law by a court or even an advocate. Misconception of the fact of the advocate, mistake of the advocate. An application for you may be necessary by witness, doctrine of. So nobody should be prejudice. That is the overall intention of the court. So here the mistake is apparent. The mistake in my humble submission is of the advocate to point out before the honorable court that they are not in service for last 15 years. That was a mistake on our part. Whether that will be a ground for review or not, that lordship will have to accept. And their own affidavit are saying, own documents are saying that they are not working as Shiksha Sharathi 1 or Shiksha Sharathi 2 beyond 2009 or 2010. My case is from 31st May 2006, the record is speaking. From 1st June, nobody was getting any salary. Nobody is in service. There was no renewal of the agreement. So that is the mistake on our part. And there is a vast difference of the case of Upendas and the case of this batch of cases. Upendas factual situation cannot be equated here because Upendas, all the employees were in service. They wanted simple regularization. Here also they wanted regularization or they are using the word absorption.
Basically, I think you want the new submission, the facts, to be brought out here in this review,
Facts which are not.
which was not there earlier, which was not there
Yes,
earlier.
it's a new fact. That is the language of Order 47. When a new fact has been discovered, was a discovery now. Because from that point of view, the SSC or the school education department did not pop the case. Our whole case was concentrating on regularization. So regulation the Honorable Court did not give. Alternatively, another limb was started, where in that case, the relevant facts would have been required. The relevant facts were not whether they are in service or not, whether their case is equally placed with the cases of the master workers or not. Had this Honorable Court knew that they are not in service for 15 years, I'm sure that order would not have been passed.
The application and the language is qualified. The discovery of new and important matters or evidence which, after the exercise of due diligence.
Yes.
What was the due diligence exercise you are speaking? This was something which was on record in earlier cases.
Yes.
That is the due diligence.
Now,
Yes, if something would have emerged which was not within your knowledge, that after due diligence, here there was no exercise of due
Yes.
diligence.
that's one way. Now, what is the submission of the SSS Council? Whether that particular question was asked to the SSS Council, whether that is the plea, whether that was pleaded in their case, that till 2017, we are in continuous service.
In paragraph 10, Mr. Chaudhary has shown.
In paragraph 3, what they have said, we are engaged in 2003 and our service continued for
No, no,
7 to
but-
8 years.
But that is in the review.
No, that is in the writ petition. In the writ petition.
The
Read
in paragraph 10, there is a
No, in
specific
paragraph 2, Lordship will kindly see.
in the writ petition.
Yes. Page 179. So during the arguments, neither side pointed out this.
Paragraph 2.
Paragraph 2. The writ petitioners beg to state that Shiksha Sharathi 1. Have Lordship of it. That the writ petitioners beg to state that Shiksha Sharathi 1, who were appointed in the year 2003 under Sarva Shiksha Abhiyan scheme within the district of Kamrup, having long pending grievances of non-receipt of their remuneration as well as against the action of the respondents to replace them by new sets of recruits after expecting their service from them for 7-8 years.
Yes, but then this writ petition was filed in 2012.
2012, absolutely correct. So what they are saying, in 2012 also they are not in service.
No, no.
So from 2003, if we add 7 years,
How, from where do you make this submission that they were not in service, or there is an admission that they were not
they
in
are,
service?
now they are in admission here. If we to take that date as 2003, kindly add 7. So it becomes 2010, 8,
8 years,
2011, and the writ petition is of 12.
Yes.
So that means they are not in service on that day also. Although their prayer is not for continuation of service. They want simply an absorption scheme. Internal page 21, page 197. And today, when in our reply, they have annexed all those certificates. So they are trying to mislead this honorable court by giving incorrect facts at different times. Whatever they have stated, it cannot be gospel truth.
okay, then what else?
Yes. Page 66. Of the APTP in the review regarding the delay.
Just a minute. Yes, yes. No, you just come on, just size them up. Order. It's, the thread has come out. Dictionary. Affidavit.
Affidavit to explain delay.
In that, I have the documents. I am going to explain the delay by the pleading.
So in
but
review.
there are certain
review.
Yes. affidavit filed by the review petitioner to explain the delay in filing the review.
Yes, but
So what I was placing was 21/11/2018 letter and the annexers there. So the abstract of release of SS1 and SS2, page 65. The first page I have read out.
yeah, yeah.
So the dates all were released now, this one. So page 65, the first were release of SS1. SS1, accordingly, a letter was issued to the districts on 29 August 2005, asking not to renew the term of engagement agreement again and let the present term of agreement automatically come to an end on expiry of the period of present agreement. Then SS2, why SS2 were released? The SS2 were released from the school with effect from 1/6/2006 for not having budget provisions in the WAWP and B 2006-7. Mention may be made that PAB of the Government of India strongly objected to deployment of any para teachers in schools of Assam, as the PTR in Assam is more favorable than the national standard. PAB has also insisted upon the issue of double salary payment, which arises as the teachers who had been taken on deputation to SSA and also persons SS2 engaged against the cost vacancies both have to be paid from the SSA budget. Accordingly, a letter was issued to all districts, excluding Karbi Anglong and Sea Hills, where SS2 were engaged on 17/5/2006 to release all the SS2 with effect from 1/6/2006 engaged in their district. The amount which was given, it is given there. Then next page. Engagement abstract note on contractual engagement and subsequent release of SS1 and SS2. Engagement of SS1, a total of 6,001 number of SS1 were engaged in single teacher school in 2004-5. Now their certificate says they were engaged in 2003. So what is the credibility of that certificate? I place one certificate where the headmaster says that that particular gentleman was engaged as Shiksha Mitra 1 in 2003. In what capacity, how? When our official record says the scheme was initiated and it was implemented in 2004 and 5 for 11 months. In all districts except NC Hills, Karbi Anglong and Sibsagar district for 11 months against agreement made between SS1 and the school management committee of the concerned school. In 2005-6, there was no provisions for extending the term of the agreement or engaging SS1 in the PAB approved meeting, Assam. Consequently, SS1 engaged earlier were released after the expiry of the term of agreement. So once for every individual, there was different 11 months period. Once that period is over, they were released. If somebody went to the school and offering voluntary service for it, we have nothing to comment on that. As a state government instrumentally SSA or a state government, Department of Education. That is the engagement, that is the relationship between the school principal and the concerned person. So for that, the burden cannot come to the state government. That is why nowhere there is a prayer that their remuneration should be paid. They only want absorption. Monthly remuneration paid to SSA was 1,500 per month. The district-wise breakup is also given for 20 number of districts. Assam has more districts, but in some districts, this scheme was not implemented. So 6,001. Now, engagement of SS2. A total of 460 number of SS2 were engaged on contractual basis at selected upper primary and secondary school. where from single subject teachers of mathematics, science, English, and Hindi got selected for engagement as CRCC, APRCC, and resource teachers. The SS2 were engaged through an agreement made between the school management committee of concerned schools and SS2. The process of engagement started in 2003-4, and most of them worked in their schools till 31st May 2006 after renewal of their term of engagement. So SS2 had a second term of SS1 only one term, SS2 two term. Next page. However, as there was no provision of engagement of SS2 in the PAB approved meeting, Assam, the SS2 were released with effect from 4 June 2006. It may be pertinent to mention that though the draft AWP and B 2006-7 SSF Assam proposed for continue of SS2, yet the PAB government of India did not approve it. So Assam government wanted to extend the term, but it was rejected by the central authority. Regarding monthly remuneration of SS2 for 2 months, April and May 2006, who worked till 31st May 2006, it may be said that the PAB approved AWP and B 2006-7 has no provisions for SS2 engagement, and effort has already been initiated to get it approved from the Ministry of Human Resource Development for payment of remuneration for the month of April and May 2006 from the APW 2006-7. It is expected that the dues of for the said 2 months could be paid once the approval on this regard is received from the State Mission Office. So for payment of April and May, that amount was obtained. Monthly remuneration of SS2 1800, 2000, 2500 in different levels of middle, high, and higher school. And the breakup of 463 is given. Now-
Is there something wrong in this report at page 65? You see, when you are referring to SS1, it is said that these were engaged during 2004-5.
Yes.
If you come to release of SS2 paragraph, it's in the same page. SS2, release of SS2, third paragraph of the same
Yes.
page, page 65.
Yes.
Here in the last time you are saying the process of engagement of SS2 was started from 2003. That means SS2 was before SS1.
It
Something
seems
is
like
wrong.
that. It seems like that.
Cannot be SS2. How can it-
No, I mean, there are
SS
different categories. SS1 is for the lower primary school and SS2 is for the upper primary.
Oh, acha, acha. Okay, okay.
Higher secondary up to
It
higher.
is not in chronology.
Not in chronology.
One to means the
Yes.
standard.
SS2 is for higher level,
Okay.
SS1 is for the lower level. It is not that once we exhaust to SS1, then SS2 is done.
I missed out that.
Now that letter of 2005. Then when this judgment came, because we wanted to implement page 70, 14 December 2018. In inviting reference from the Joint Secretary to Elementary Education to the Admission Director, in inviting reference to your letter on the subject cited above, I am directed to state that the information on the period of engagement and professional qualification, etc. of Shiksha Sarathi submitted your letter under reference is inadequate in respect of the following districts as shown in details. Kacha regarding Shiksha Sarathi 1 task not mentioned in respect of most of the candidates. In respect of Shiksha Sarathi task not mentioned in all candidates. Education qualification not mentioned in serial number 22. Rupri also, 2 dates were mentioned in the column date of joining. Tenure column has been left blank in respect of most of the candidates. Column of task and qualification is not there, serial number 3. 4, in respect of Shiksha Sarathi 2, column of date of release, total tenure has been left blank. The column caste and educational qualification have been left blank in respect of serial number so and so. In Dibrugarh also there are discrepancies. In respect of Shiksha Sarathi, the column total tenure has been left blank. Total date of joining has been left blank in Golagwalpara. And in Golaghat, column of date of joining, date of release, total tenure caste have been left blank in respect of most of the candidates. In Hailakandi, date of joining and date of release have been left blank. Kamrup, date of release, tenure have been left blank. Lakhimpur, Morikawa is identical. You are requested to complete arrangement of submission of complete information at the earliest. Then another letter of 29th December 2018. In inviting reference department return of subject that I am therefore requested to kindly furnish the information as sought for therein to the government immediately. Because government needs to formulate a policy. So all this information is required. So that delay part also I am trying to explain through these documents. That we are not sitting idle, we are doing the exercise for implementing the judgment. Now, a letter on 19th January 2019 to the Senior Standing Council from the Joint Secretary Elementary Education. With reference, I am directed to state that the policy for engagement of successor has been adopted by this department in the same line of policy already adopted in respect of Sanjugi Shiksha Karmi, which was finalized in a meeting with the representative of Sanjugi Shiksha Karmi Union, copies of minutes and close. The same policy will be adopted in case of Shiksha Sarathi as well. The policy will have the following points. Steps will be taken for holding a special test for Shiksha Sarathi who have been completed 10 years of continuous engagement under SSA from time to time on contractual basis. Special test will be held tentatively in the second quarter of 2019. All candidates who will appear in the special test must have the requisite qualification as per latest.
Okay, you're saying this to show that you are taking steps.
You are taking lordship. It is not the first time that Shiksha Sarathi has been engaged or absorbed. In 2013-14, if I remember correctly, lordship, we had a case. The Honorable Court directed that they cannot be regularized. Government suo moto took up the matter that if they are really working for such a long time, let us have a special tab for the Shiksha Sarathi, Shiksha Mitras. Shiksha Mitras. Give them that opportunity to participate in, because RTE Act of 2009 is very specific that we have to follow the NCT norm, which also includes DET, apart from the other educational qualifications. So we held that, and most of the 80-90% of the Shiksha Mitras were worked to the mainstream. That means they are engaged as regular employees. Government is not against their lordship. Let us be very honest and frank before the Congress. We wanted to do. Therefore, all these exercises are being done. When we finally come to know that they were not in service for 15 years, then we come before the Honorable Court for a review. So, one batch of Shiksha Mitras, they are already part of the education system now as teachers, assistant teachers. Whoever worked for such long time, we gave them the opportunity and they came up. Normal students were not allowed to participate in those special tests. So special test was conducted for Shiksha Mitras. I can give the date 2013-14 in that period. So now serial number 3, the candidates who qualify for the special test will be eligible to apply against regular vacancy of teachers in LP and UP when regular advertisements are being published.
The thing what you're saying now is basically a taking step.
No, we have taken further steps.
What do you want to show with when you're reading this?
What I am trying to say before this Honorable Court that when we try to implement the,
You could not do it because they did not have that, they were not in service.
they are not in service. They are not in service, and not in service for not for 1 year or 2 years. From 2006, 1st June was the last day they were in service. And this Honorable Court did not extend their term. My Lord Justice Gogoi's judgment. They all came for the before the Honorable Court for extension. These facts were not there before the Honorable Division Bench. What is
I think basically that's the case. Their case is that they were this Shiksha Sarathi. They did not, they were not employed by the government beyond 31st May 2006. However, this fact has not been brought to the notice of the court.
Whether for that default, whether that judgment can be implemented or not, as it, or there needs some modification.
Accordingly, a review is not for because this fact was not brought to the notice of the Lord. That's the basic thing.
That's why my first liner was like that. That judgment of the learned single judge of 2005 and the report of the mission director Tiwari's report and what is his submission before the learned single judge. It is not that on affidavit. He came before the honorable court and submitted. All these were recorded, judicially recorded statements. We cannot ignore them, Lordship, now. And on top of that, we cannot reverse the spectral position of it. The ground reality is totally different. May I continue on the next report? Because I have to place the judgments also.
So judgments will give you time. But what is on the factual aspect, what is there to submit? There's nothing else to submit. That is the
Only thing is that their own admission in the further paragraphs also, paragraph 10, paragraph 14,
of the review.
no, of the repetition of 2012. All these things, because paragraph 10 also they have stated. They said, although the agreements were signed on 13/9/2004 for 11, virtually their engagement continued up to 2010. Virtually, what is virtually continued?
So
Virtual, physical. It is their word, not our word.
okay, so what you can do is we'll fix another date.
Yes, Lord.
You make a short
Yes, I'll be very concise.
have it written down
Yes,
so that we don't have to go through the entire
absolutely,
thing
Lord.
and with the pages and things.
Great way, I can
And
very
give us
concise
the-
way.
Yes, and your citations also.
Citations and the main paragraph.
And the main paragraph can be mentioned.
I'll do that. In fact, 3 special benches were considered today for our cases. That's why I could not fully prepare. My friend was also there in 2 cases against me. At 10:15, 2 special benches and only our matters. And before the division bench, 1 matter very keenly fought. That matter was also simultaneously we have to take adjournment.
Anyway, so next time, I don't think you will take much time.
No, I'll not.
You take maybe half an hour at the most.
Maybe, max.
Then I think we can hear him a little bit, just a little bit. And you also can give us your list of judgments.
Yes,
which
I'll
are-
be very precise. I'll basically say it's not a case of, what my learned friend is saying may be absolutely correct. But even then, this cannot be a ground for it. Maybe he's absolutely 101% correct. He cannot, lordship will not reappreciate evidence in a review, my lord. That's the subtle position of law. It will amount to reappreciating the evidence. That lordship will never do.
We don't know, maybe his intention is
Oh my
to,
lord.
no.
State
May-
is not
maybe-
remediless. If state feels that this order, in this order of the learned full bench of this honorable court, some incongruities have crept in, state is not remediless. The remedy is not review alone. I am on that mind.
No. His idea may be
Ah.
to ensure that these new facts come into play here, so that when he goes to the Supreme Court, he can argue all the acts.
Of course.
And my friend is very fond of going to that.
No, nowadays I'm not. My lord,
Very-
Mart is
very
a better place. Nowadays, Vantage is there.
6,001 plus
say-
460.
Anyway, my lord, we are before your lordship only for
So we have to see the
36.
number of petitions.
36, my lord. We are before your lordship only for 36 Shiksha Sarathis of Kamrup district. We are not representing 6,000 plus. 400.
Anyway,
We are only for 36
anyway, we do not know. You all know better than us.
No, my lord.
Maybe the review petitioner wants us to record.
Create
the new
grounds
facts.
for,
Yes, for the Supreme Court. Could be, or maybe not. Or maybe he has got a very good basis for saying, for coming to counter para 42 of the judge. So that is the basic thing,
Absolutely.
para 42.
I have had only paragraph 42 of the review. From where that 2 decades thing has come up.
So we'll try to shorten everything and finish it up next.
Yes,
I
yes.
thought this- I thought we could finish up this afternoon itself.
That is another ground why it is not a review matter. Because error apparent on the face of the records is an
So
error.
immediately we
To find it out, it should take 15 minutes, not more than that, including
One,
judgment.
two documents I placed at the very beginning, that was sufficient ground for it. Two documents, the judgment of the learned
Okay,
signature
we'll-
and the letter of the MDA of 2005. These two letters are sufficient. And the third document, there is certificates.
So when do you all want? You all fix the date, both of you.
Let
are
it be
fixed
after
on-
the room.
After you.
The
Or-
Lordship will again
So
have to
from
go
nine-
through again. So if it is nearer, it is better.
No, my lord, problem is on,
Even I have a very tight schedule, but still I am saying because Lordship has
27th and 28th, I'm not there. That's the only. That's why I said, oh, maybe first week of April. Before you also, but not 9. Today, my lord, all the CA matters have been fixed on 9.
third of
Third.
April.
Oh, yes, yes.
That is a motion day.
Then fourth of,
Since your lordship will take only 1 hour,
Ah.
can keep it at 3 o'clock.
so
Motion is,
Oh,
motion day. is-
sorry, second.
fourth of
Second, yes,
Thursday.
second.
Fourth is the, fourth of second, fourth,
Fourth, second.
fourth, I,
What, my lord, in the second.
naturally. Right. On the prayer made by the, by the AG, Mr. Chief Secretary, Mr. K. Joseph. This is the matter of fourth. At 2 p.m.
Let it be in the normal list slot. Oh, this bench will have to be split. Let it be at the 10:30 lot, 10:50.
Then
Because my plan, although says he will take very short time, but before my starting, he will start early.
that,
he will take all the time.
that is my worry. That will take the whole day.
I'm absolutely correct on
My
that.
lord, in a review matter, I'll cite the judgment, give the paragraph. I'll be just
Correct.
40.
So, at 2 o'clock.
No
Yes.
problem. Lordship.
There was one judgment you had referred to.
Yes, 2013, 8 SCC,
Tara?
my lord, para 17, 18 and 20.